I'm Andrew Rodriguez, and welcome to Psycho Bible, battling about psychology and theology. I'm going to do a special video today doing commentary on the Supreme Court's hearing of Kaley Chiles versus Salazar. In other words, Kaley Chiles, a Christian counselor in Colorado, challenging Colorado's ban against so-called conversion therapy for minors. Therapy for helping people explore changes in what they call sexual orientation and gender identity. And so this has been a major case for us. We've been fighting this fight since 2012. For years, even earlier than that, fighting the propaganda that led to the first conversion therapy ban for minors in California in 2012. And I've had colleagues, friends of mine, who have fought against different bans. They've lost, some have won. But we've been needing the Supreme Court to weigh in for quite some time. And a few years ago, a Christian counselor in Colorado, Kaley Chiles, decided to fight her state's ban. Lost at different levels, went through appeals, and made it to the Supreme Court. And so, we're so proud of Kaley. I had the honor a few weeks ago when I was at the American Association of Christian Counselors Conference in Nashville of meeting Kaley Chiles, who was there, and my colleague and I, Dr. Christopher Rossick, we were co-presenting, and so we got to speak with her and hear her and one of the lawyers from the Alliance Defending Freedom speak and give us an update on everything. And so just cheering her on. I know it was not an easy decision for her and her husband to fight against this ban, but we're so happy she is taking the fight, and she's pretty chill therapist. Like, she's it's not the type you would think who would take the whole state to task and the whole country to task on this issue. Like, she just seems like a really cool, like, easygoing girl, but yeah, she's got some fight in her, and so we're very proud of her. So last Tuesday, October 7th, her team got to present their arguments to the Supreme Court of the United States, and it was live streamed. It got the audio recordings. I'm using C-SPAN's recording because they throw in pictures of who's speaking. So if you're not too familiar with each judge or each justice and how their voices sound, you'll be really confused. So I appreciate that they put in their pictures. And so we're just going to go through, and I'll add my commentary as we go along through this whole recording. Thank you so much for watching.
We will hear argument first this morning in Case 24-539, Chiles versus Salazar. Mr. Campbell.
Thank you, Mr. Chief Justice, and may it please the Court. Colorado forbids counselors like Kaley Chiles from helping minors pursue state disfavored goals on issues of gender and sexuality. This law prophylactically bans voluntary conversations, censoring widely held views on debated moral, religious, and scientific questions. Aside from this law and recent ones like it, Colorado hasn't identified any similar viewpoint-based bans on counseling. These laws are historic outliers. In NIFLA, this court protected professional speech, highlighting the dangers of censoring private conversations between professionals and their clients.
Real quick, NIFLA is a case in which a state ordinance required like crisis pregnancy centers, women's centers that were pro-life, to also recommend that their patients or women coming to them for consultations be referred to Planned Parenthood or abortion clinics, or at least have their information given to them. And that violated, of course, the mission of these crisis pregnancy centers. And so they refused because they're requiring them to, they're giving dictation to these providers about how they should discuss pregnancy issues with their patients, what the reasons for these women coming to them for help. And so in that case, the state was trying to say that, well, there's a difference between free speech and professional speech. And so we can regulate professional speech. If you're a clinician, but not if you're a non-clinician, as if that's a different status of citizen. So the Supreme Court ruled in the NIFLA case that no, there is no such distinction between free speech and professional speech. So that's what that's referring to.
And this court rejected by name 2 lower court decisions upholding laws like Colorado's. But the 10th Circuit gutted NIFLA speech protection. Colorado insists that its law is subject only to rational basis review. Yet that would allow states to silence all kinds of speech in the counseling room, such as disfavored views on divorce or abortion. If heightened scrutiny doesn't apply, states can transform counselors into mouthpieces for the government. Here, Colorado can't satisfy any level of heightened scrutiny. It didn't seriously consider any less restrictive alternatives, and Colorado can't prove harm because it hasn't cited a study focusing on what's at issue here: voluntary speech between a licensed professional and a minor. Nor can Colorado deny that many people have experienced life-changing benefits from the kind of counseling that Ms. Chiles wants to provide. The First Amendment doesn't permit Colorado's censorship. I welcome the court's questions.
In its introduction of its brief, Colorado says that the only thing that the law prohibits therapists from doing is performing a treatment that seeks the predetermined outcome of changing a minor's sexual orientation or gender identity because the treatment is unsafe and ineffective. 1, is this what Colorado argued below? And 2, is that your reading of the Colorado statute?
Colorado took a different position below in its motion to dismiss, specifically footnote 3, and on page 10 of its opposition to the motion for preliminary injunction. It recognized that efforts to change unwanted same-sex behavior or to reduce unwanted same-sex attraction would indeed violate the law, and that's contrary to the position it's taking now.
So what he's referring to when they made their case to go to the Supreme Court, Colorado tried to dismiss their case, or made a motion to dismiss, because even though the law states plainly that they consider conversion therapy, even any techniques, not to categorically, or not only to categorically change someone's so-called sexual orientation from homosexual or bisexual toward heterosexual, but even just to reduce the attractions or to change the behavior. That's explicit in the law. And in their motion to dismiss, they try to say, no, we don't mean it that way. That's not how we interpret it. And so if she's just doing counseling with someone to help reduce behavior or reduce the attractions, then we would not enforce the law in that situation. So they try to reinterpret the law in their motion to dismiss.
I do think if we look at the plain language of the statute, we will find that what Ms. Chiles alleges in this case falls squarely within it. The statute says that there can be no efforts to change sexual orientation or gender identity, including efforts to change behavior, gender expression, or attraction. On page 207 of the petition appendix, Ms. Chiles alleges in her verified complaint that sometimes she helps clients who want to reduce unwanted same-sex attraction, change unwanted same-sex behavior, and to resolve dysphoria that they're experiencing with their bodies.
Counsel,
all of that.
You are right that fits the definition of the law. But we have been very clear in Susan B. Anthony that there has to be a sufficiently eminent and credible threat of prosecution. We've said merely having a law on the books is not enough. A chilling effect doesn't exist.
That really bothered me when Sotomayor starts saying a chilling effect does not exist. Yes, there is. Everyone is terrified. Even people who are even in disagreement with LGBTQ indoctrination and are even favorable toward therapies that would help people explore change in sexual attractions or helping them resolve gender identity conflicts to actually be in alignment with reality, with their bodies. They're still terrified to do any sort of therapeutic effort to help clients because of that chilling effect. They're terrified of being accused of being a so-called conversion therapist. So the chilling effect is quite real. She's in denial of reality here. And the ridiculousness of this, that, oh, she shouldn't try to oppose this law until she gets prosecuted, until she gets in trouble by the law. Well, if the law exists and it's unconstitutional, it should be fought preemptively. We should at least make every effort to, rather than being if she were to wait until she got in trouble, then she would look like a rogue therapist who is a maverick who doesn't care at all about legality. So it's better for her, in her case, to actually preemptively go after the law. And now she's trying to say, well, that doesn't give her standing. It's the line of questioning from Sotomayor throughout the opening minutes of James Campbell making his case for Alliance Defending Freedom is just, it's abhorrent. She just gets hung up on nitpicking, trying to dismiss the case ultimately over technicalities, and not really hearing the merits of this case, really. About, ultimately, yes, it is a violation of constitutional rights. So I cannot stand that she denies the chilling effect, which is very real.
This is an unusual case because we have basically 6 years of no enforcement of this law, 3 before this lawsuit, 3 since. And we have the entity charged with administering the law saying we're not going to apply it to your kind of therapy.
Think about how stupid that is. So the state passes a law that is so overreaching, it bans all and any form of counseling for changing someone's so-called sexual orientation toward heterosexuality and gender identity toward aligning with reality, with their biology. But then they'll say, well, we won't enforce it. So then why have the law? If you're going to pass a law that you're not going to enforce, then why have the law? Remove the law. If you want to make a law that prohibits abusive forms of therapy, like, what everyone thinks conversion therapy is, torture and aversive techniques and electroshock, then narrow it down to that. Make a law specifically about you may not use aversive techniques to help clients with unwanted same-sex attraction or gender identity confusion. Okay. Literally no one will oppose that. Like, we would happily sign that into law, of course. But no, they want to ban your right as a client to choose your own therapy goals. That's ultimately what it's about. And of course it hasn't been enforced because barely any therapists are willing to therefore stick their neck out there, and most of the therapists are all indoctrinated. In fact, you can't get a license these days without paying lip service at least to the indoctrination that doing any form of so-called conversion therapy is unethical and harmful. So few therapists in their right mind, if they don't really have much of a dog in this fight, are going to attempt something like this that would get them in trouble with the ban. So, of course, the law hasn't been enforced in the 6 years in which it came into effect. Doesn't mean it's unjust and it shouldn't be overturned.
So how does that fit into being an imminent threat of prosecution? Yes, you have an argument. They've disavowed it. How does that give you standing?
I don't believe that the state has disavowed enforcement. The state is relying on a misreading of the allegations in this case to say that there's no standing, but they have not disavowed enforcement. If Colorado truly believed that it wouldn't enforce the law and that Ms. Chiles wasn't...
So tell me what kind of disavowal you would need to find no standing.
The disavowing I say they would need is to repeal the law. Get rid of it. Because the way it's worded means that at any point they can enforce it. They might say right now they're not going to enforce it based on her just doing plain old talk therapy with a client who's voluntarily seeking help. But she's running a risk doing that because of the way the law is actually written. So it doesn't really matter how they choose to interpret it right now. If by the way the law is written, she is under threat of being prosecuted under it, then the only disavowal that really counts is them repealing the law.
Would it be sufficient to say that consent, which is what your complaint claimed, that your therapy is consensual talk therapy, where you would seek to change the behavior of a child only if that's what they want, correct? Am I articulating it correctly?
That is certainly an aspect of what
No,
Ms. Chiles
I don't want an
alleges.
aspect. Define your talk therapy, and then when they get up, they can tell us whether they're disavowing any enforcement of that kind of talk therapy.
I would go back to what I referenced before, which is Petition Appendix page 207.
Counselor, please answer my question.
I'm trying to answer
What is your
question.
talk therapy, and that you want them to say they will not enforce it against?
Ms. Chiles helps clients when their goals are to resolve gender dysphoria by getting comfortable with their body and realigning their identity with their sex. She also helps them if they're experiencing unwanted same-sex attraction, if that's their goal to reduce it, and she helps them deal with issues of unwanted same-sex behavior. That's the kind of counseling that we've alleged in the complaint. And here there's
Would
a credible...
any of that include what's talked about as aversion therapy, which is encouraging them to vomit, encouraging them to go into electric shock treatment, encouraging the typical aversion therapy?
The typical version? This threw me for a loop. I can't believe she actually said this. This just shows how ignorant people are. Even people who are supposed to be so educated on the matter. And she would have read the briefs, all the amicus briefs that were sent in. I'm assuming she was at least informed about them and the consensus. No one uses aversive techniques like electroshock and induced vomiting and like bamboo torture or like hitting themselves or whatever idea she has in her head about aversive techniques being used for same-sex attraction or gender dysphoria. No one does that. If it has been done, it was, like I've said in previous videos, decades ago, at the latest, the 80s. A small remnant of maybe behaviorists might have still been doing some degree of aversive techniques. But primarily we're talking about the 50s and 60s. And that wasn't even ubiquitous. It wasn't even that's the main approach used. The main approach for decades was the psychoanalytic approach of free association and talking and interpretation and transference with the therapist. So entirely talk therapy. That's the typical and historic approach. If you want to look at the whole scope of modern psychotherapy in America. So this, I can't believe she said that, the typical version. These are the lies that we have to deal with, the propaganda that we have to deal with on a regular basis just to advocate for clients to obtain therapy that aligns with their values. We have to hear this constant myth that we're using aversive techniques, that we're torturing clients, we're causing them harm directly. And she's going to espouse this. It makes her look totally ignorant.
No, Ms. Chiles does not do any of that. All she does is speech in her counseling.
And so what behavior does that include? Does that include date other people of your
No,
the opposite sex?
No, she does not. That's not the kind of counseling she engages in. She engages in a discussion where her and the clients explore the concepts of identity,
So
behavior.
go back to my last part of my question. If they disavow enforcement of that kind of talk therapy, do you have standing in this case?
We still have standing in this case. Over the last few weeks, there have been anonymous complaints filed against my client, and those complaints are now being investigated by the state of Colorado for allegations that she's violating the very law that we're challenging.
Exactly. This is what happened to me. when I was getting my license, someone made an anonymous complaint to my state board, not a client, probably just someone who sees me on YouTube since I'm a very public figure and I'm an advocate for what they all like to call conversion therapy, but I'm just doing good professional therapy, in particular reintegrative therapy, and because that gets labeled as so-called conversion therapy, that's sufficient based on their super broad definition, that led to a state board investigation. And as long as there are these bans that are out there, it's an invitation for these frivolous complaints, whether from clients who are actually plants, people who are like seeing me as a client undercover so they can try to find some dirt on me in order to try to take me down, or if it's just anonymous people who aren't even clients, who never met me in their life, can just contact the state board and try to take me down. Every therapist who does this type of work is vulnerable to that, as long as there are these so-called bans out there, or not so-called, but as long as there are these bans out there, whether it's even for states where there is a ban, because the field is so hostile to anything that is not pro-LGBTQ, if you just are a therapist who has a different ideology, a different worldview, that is sufficient for them to view you as scrutiny and suspicion of being a so-called conversion therapist. So conservative therapists, who are already small in number compared to the majority out there, are constantly under the gun.
So we had a credible threat of enforcement before because there's no disavowal. Anyone can file a complaint at any time, which this court recognized bolsters a credible threat of enforcement and SBA list. But now that the state is actively investigating our client for supposedly violating this law.
Okay, we're in a vicious cycle, because if they get up here and say they're disavowing, then they won't be investigating.
But regardless, if they disavow, it's only based on not only a misreading of the statute, but also a misreading of the allegations in the complaint. As we pointed out in our reply brief, there are often uses of portions of quotes, and the state of Colorado is ignoring the rest of the sentences in the allegations. Once those are read, just as the lower courts found, there is standing in this case.
Exactly. Their disavowal is entirely based on a misreading, a deceptive misreading, because what they know what the implications of a plain reading of this law entails. When you say that conversion therapy is any attempt to change orientation, and that includes just simply reducing the attractions or changing the behavior, then you have to be intentionally misleading people by saying, well, we disavow this, or we're not going to enforce it, when all you're doing is helping people change behavior voluntarily and helping them explore the routes to the same-sex attraction that might lead to the attractions actually reducing. So there's no real guarantee. That would not satisfy me if they just said, well, we'll disavow an accurate reading of this law. So James Campbell here is exactly right, that this disavowal would be based off of a misreading. And I would add to that, because I'm not necessarily in the court there. I can be a little more accusatory. I would add that it's a very intentional, deceptive misreading.
Counsel, how does your position change if, in addition to the counseling, there is more, what I'll call medical treatment, whether it's medications, shots, whatever? Does that alter your position?
It certainly does alter our position. So as this court talked about in NIFLA, when speech is incidental to regulated conduct, then that changes the analysis. And so if we were in the medical context and there was something like administering drugs, performing procedures, conducting examinations, that would take it outside of the arguments we're making.
How about
into
if it's just both? In other words, the speech isn't incidental to giving somebody a prescription for medicine. It's speech and it's giving somebody a prescription for medicine.
It would depend on how closely connected they are. So if the speech is describing how to take the medication, then that would be incidental.
Right, but if the speech is the speech that your client engages in, and in addition, she engages in something that's non-speech, would we look at it separately or would we look at it as a package?
If they're sufficiently disconnected, I think you would look at them separately. And my client doesn't have the authority to prescribe drugs because she's not a psychiatrist. And the state of Colorado recognizes that there's a very big difference because it treats psychiatrists under Section 240 of the code and it treats counselors under 245. And that's a recognition that it's just different regulation when medicine is at issue. In this case, Colorado is violating the promise that this court laid out in NIFLA, which is that states should not manipulate private conversations between licensed professionals and clients. Beyond
So
that,
how would this apply to a malpractice suit? Let's say that we think that this is content discrimination and it triggers strict scrutiny. Would your client then be subject to a malpractice suit?
She would be subject to a malpractice suit, but she would have the protection of the rigorous elements of malpractice. She would be able to show that she's not violating the standard of care, that she would be able to establish what the standard of care is. She would be able to show there's no harm and there's no causation.
Well, I assume there would be a battle about the standard of care with, competing experts, competing medical associations. Colorado's pointed to some professional associations in this case. Would the First Amendment have anything to say about that? I mean, would it be strict scrutiny? I mean, it's the elements of a tort. It's a different thing. We didn't get to this question in Snyder.
As a general matter, the elements of a malpractice suit are sufficient to protect freedom of speech. Now, I'm not willing to foreclose the fact that there might not be an argument someone might make in a particular malpractice case. But for our purposes, the elements of malpractice are generally sufficient to protect free speech. And in this case, the court doesn't need to resolve whether there might be additional protection, because the way that Colorado is using malpractice is as an analog to what it's doing here. But it's nothing like
Well,
the law that
I
we're
wasn't
challenging.
actually asking about the analog argument. I was just asking it independently. So.
Can I just ask you to say on page 18 of your reply brief that, in fact, a malpractice suit could go forward and completely separate from the First Amendment, that what you need to prove a malpractice suit provides sufficient protection. Is that a right reading of what you said?
It is a right reading, although we said that those elements are generally sufficient. So I don't want to foreclose that in a particular case there might be an argument, but generally speaking, a malpractice action subject to the rigorous elements would be sufficient to protect free speech.
Can I get you to address whether or not the provision of therapy and the kind of therapy that your client practices is a medical treatment? I mean, I understood the sort of basis of the 10th Circuit's view to be that she's a licensed professional who is providing medical treatment, but your answers to the Chief Justice and Justice Kagan suggested that you're putting the practice of medicine on one side and her therapy on another. So I'm just unclear as to whether or not you're categorizing her therapy as a medical treatment.
As much as I'm not a fan of Ketanji Brown Jackson, she does bring up a point here that I think all therapists should take heed, and that is, this is one of the problems we get into when we fought for parity laws and for therapy to be treated the same as other sorts of medical treatment. When we started categorizing mental health as the same exact thing as medical issues, and so therefore therapists who are not medical professionals, there's no way I'm a medical professional. I did not have to go to medical school or pre-med in order to become a therapist. Half the more than half of the therapists that are graduating in graduate schools right now, I would trust to have any opinion of any value when it comes to medical issues, let alone psychology issues these days. It's totally inappropriate. It's totally inappropriate to me for mental health counselors to be viewed as medical professionals. I am very much, at least critical, if not totally against, the medical model, because then this boxes people in to think that they can only provide counseling or use psychotherapy when there is a medical diagnosis, even that medical diagnosis is a subtype, which we call a mental health diagnosis or mental disorder diagnosis. And that's just simply not true. you can utilize psychotherapy for a wide range of issues, not just actual disorders. No one needs to have a disorder in order to get marriage and family therapy, nor to do coaching or to do more positive psychology and work on more positive goals when you're not really working just on a problem, but just work on self-enhancement. So the discipline of psychotherapy can be utilized in more ways than just treating a disorder. But the medical model has conditioned us all to view things in terms of disorders so that we can only treat something or work on an issue if there's a diagnosis for it. Hence why the DSM has exploded with diagnoses. Your child is misbehaving, then they have conduct disorder. We need a disorder now in order to just do good parenting counseling and disciplinary counseling and counseling just for training kids to be well behaved. So the fixation on having a disorder has been a major sticking point when it comes to people seeking counseling for unwanted same-sex attraction. Because 1973 they removed homosexuality from the DSM, and they kept it in there for several years under ego-dystonic homosexuality. So if your homosexuality was not aligned with your intrinsic sense of self, then it was valid for you to get counseling for it. But then they removed that in the 80s, I think 86. So now with the out of the DSM, they can say, oh, it's not a disorder, so therefore you can't get counseling for it. But this is a misunderstanding of the application of psychology and of psychotherapy. You can get psychotherapy for any issue. The problem is, for it to get paid by insurance companies, it needs to have a diagnosis. And so that is where the issue is. Everyone wants to use their insurance to pay for therapy. And therapists deserve to get paid, and so most people who can't afford to pay private pay rates don't end up seeing a therapist who operates outside the insurance system. So that is a challenge, but as the route I choose to take, I do not want an insurance company and having diagnoses dictate which clients can see me. But yeah, this is a major concern I have. We've been way too dependent on what we're treating clients for having to have a diagnosis code in order to justify treatment.
I don't believe that we are categorizing it that way, but I don't think it matters because the First Amendment depends on the difference between speech and conduct, not on the difference between treatment and non-treatment. So in my response to
But I guess the argument that the Tenth Circuit seemed to find persuasive was that if you are in the world of medical treatment, you are regulating conduct, that the medical treatment itself is an activity that is being licensed and that is being performed, and that it really isn't speech, that speech is the tool that is being used, just like in other medical treatments. You have scalpels, you have tools that medical professionals use to accomplish certain goals and to provide treatment. And so in that sense, I think their argument was that speech is incidental to the provision of this medical treatment. So I guess we need to understand whether her therapy qualifies as medical treatment.
The question is whether her speech is incidental to conduct. That's what the court said in NIFLA. It said that if there's professional conduct, then speech that's incidental to that could be regulated.
So treatment is not conduct in your view, medical treatment.
If the treatment consists only of speech, then it doesn't trigger the speech incidental to conduct doctrine. And here we're just in First Amendment land where there is full, robust protection. That's why I answered the Chief Justice's questions differently and acknowledged that if there was conduct in the practice of medicine going on.
Okay, so what might confuse some people is they're referring to speech versus conduct. So what is the difference? Generally, it's understood that professional conduct refers to the activities or actions and behaviors expected of individuals in their professional roles or their capacities, while professional speech involves communication that's based on their expert knowledge as a therapist in this situation, and it's in the context of a therapist-client relationship. So, as an illustration, if you're seeing your doctor and you're talking about wanting to lose weight, the doctor can give you some expert advice on diets and exercise and strategies for losing weight, and that would just be speech. That's all his treatment consisted of. However, the doctor may also prescribe medication like Ozempic or some other weight loss pill. And so that behavior, that action would be considered conduct. And while he's administering or prescribing, he will generally also give instructions to the patient and advice on when to take it and what to take it with, etc. And so there's speech that is incidental to the conduct. So hopefully that clarifies this. What Kaley Chiles' team is arguing is that in her capacities as a therapist, her treatment consists only of speech. She's not doing some sort of conduct, so administering some sort of behavior or treatment on the client that is something beyond speaking with the client, engaging in conversation and helping the client explore things through conversation, and using her professional training as a therapist. So she's not doing something beyond the scope of what she's trained to do. So that is the crux of the argument, really.
It changes the
But I guess it
analysis.
seems very odd that you could have two scenarios where you have two licensed professionals both attempting to provide treatment to an individual, say for this same issue, that, the person says, I'd like to live consistently with my biological sex. I feel that I'm not doing that. I'd like your help. Medical professional A treats that quote-unquote condition with medication. Medical professional B treats that condition with talk therapy. And I guess under your theory, those two scenarios are sufficiently different from a constitutional perspective that one could be allowed and the other not.
I think that's potentially correct, because the First Amendment would apply to the speech.
Just because
therapy.
words are being used to accomplish the therapy in one scenario and not the other.
This really shouldn't be that hard to understand.
No, because only words are being used in the one scenario. Again, if there is a combination of words and conduct, I think that takes us into a different realm. But one of the things that's so problematic about Colorado's law is that it undermines the well-being of kids that are struggling with gender dysphoria. And so Colorado accepts that up to 90% of kids who struggle with that before puberty will work their way through it and realign their identity with their sex. But this law says that if any of those children go to a licensed professional and say, I would like help realigning my identity with my sex, that licensed professional has to decline to help them. On the other hand,
analysis apply if the law is not this law? I think Colorado has something like the law I'm going to describe, but I'm not trying to describe Colorado's law. Just take it as my hypothetical. If instead of this law, which really focuses on the kinds of treatment it is and the kinds of goals everybody has, it just says you're subject to penalties if you do any medical treatment, and that includes talk therapy, that deviates from the standard of care. And then it goes on to say something about how we find the standard of care. And suppose that sort of law was applied to your client. Is it the same analysis or a different one?
I think it's a similar analysis. So if a law like that were applied against my client and all she did was speak, then I believe that the strict scrutiny analysis would apply and the government would have to satisfy it. But the underlying analysis would change somewhat too, because my client under those circumstances would be able to establish that the kind of counseling she provides is consistent with the standard of care, versus under the current law, she's not able to make that showing.
Right, so she is able to make that showing under my hypothetical law, but you're saying still not, that she would have a kind of separate argument that there needed to be strict scrutiny applied.
She would. She would be able to argue that, and that would require the other side to show that what she's doing is causing harm, because that ties into what this court's recognized in cases like Brown under strict scrutiny.
Thank you, counsel. Justice Thomas? Justice Alito? Justice Sotomayor?
Counselor, in your introduction, you appeared to be applying strict scrutiny. One of the factors you said is the state has not pointed to a study that shows that talk therapy is harmful. I don't believe strict scrutiny always requires a study.
Oh, here's here's another part that Sotomayor got me pretty angry, because this like James Campbell argued in the beginning, laws like this, these so-called conversion therapy bans, are outliers. There are no other laws that limit the type of advice a therapist can give a client, that type of discussion a therapist and client can engage in, that discriminates against particular worldviews. And so if you're going to violate free speech to that extent, in particular violate the client's right to autonomy or self-determination, which is one of the ethical principles that all of the all of the medical associations or the mental health associations and social work associations and marriage and family associations hold to, you have to justify that. And if you're going to say that, well, to make change in so-called sexual orientation or gender identity a therapeutic goal is innately harmful, to make it so that doesn't matter what the mechanism is, what the therapeutic approach is, that it is harmful no matter what, just because the goal itself is harmful. That is such a gross violation of the client's right to self-determination and autonomy that you better have the proof to justify it. So in this sort of case, yes, there better be study after study proving overwhelmingly that it doesn't matter what approach is used, it is harmful. Doesn't matter if it's done by a licensed professional or an unlicensed professional, it's harmful. Doesn't matter if they're using aversive techniques or just plain talk therapy, it is harmful. Doesn't matter if it's coercive or client initiated, it's harmful. And none of the studies out there showing harm that they say proves how harmful this is make any of those distinctions. So yes, a study, at least one study, should be required to justify this gross violation of client rights, not to mention therapist rights for free speech.
I mean, look, I'll give you a hypothetical. A state tells dietitians, don't encourage anorexic patients to engage in more restricted eating. All right? I don't think the state has to provide a study to show that that advice is not sound. Do you agree?
Well, no, duh. The state shouldn't have to produce a study to tell a therapist not to recommend a client with anorexia to engage in more restrictive eating. That's a no-brainer. Of course they wouldn't need to use a study for that justification, because it's readily apparent that that is running counter to the client's goals. If the client's come to them for treatment for anorexia, they're like, I know what I'm doing is harming myself by restricting my eating, by purging. I'm compulsively doing it though because I'm confused in my mind about what I need to do to be healthy, about my body, about my image. And so I keep giving into this behavior to restrict or to purge, and it's destructive. And so not only is it something most clients are aware of, but even if the client wasn't aware of that, it's readily apparent that this would be counterproductive for the client. And also, to my earlier point, this is targeting the example she gives is targeting a very specific approach. Okay? Whereas these so-called conversion therapy bans don't make any distinctions about approaches being used. So they're not saying, okay, you can help clients with exploring change in their sexual orientation or sexual attractions and their gender identity, as long as you're not using this particular approach, as long as you're not using electroconvulsive therapy, as long as you're not using any aversive techniques. Other approaches you may use, as long as they're mostly evidence-based, they're widely accepted therapeutic approaches that we can use for a variety of issues, not just this. Like, if you want to make that stipulation, if you want to make it, like they're saying at the beginning of their arguments, that they could have used the least restrictive language in this therapy ban, we wouldn't be in court today, okay? But instead, we have a super broad definition of so-called conversion therapy and a ban for anything that looks like that.
Justice Sotomayor, I think that might be true, but that's because that kind of hypothetical is very different than what we have here.
So explain the difference.
In that hypothetical, the counselor or dietitian is telling the client to do something that directly harms their body. In this case, Ms. Chiles is trying to help gender dysphoric kids avoid...
That begs the question, because there are studies that say that this advice does harm the people emotionally and physically.
And there are studies that show that it doesn't harm, that it actually benefits people. So we got conflicting studies. So no, it's not begging the question.
But putting that aside, you agree then that you don't always need a study. An absolute statement like that misstates the law.
No, what I agree is that if what the state is getting at is a statement by a professional that's telling someone to harm their body, that's a different category. But if we're in a situation like this, where there is debated science, where the counselor is trying to help the child achieve their goals, then absolutely the standard this court set in Brown would apply, which requires a showing of causation.
So there's only one circuit that has applied strict scrutiny to this kind of thought therapy. It's the 11th. The others, the 9th and the 3rd, have not. You seem to be encouraging us to apply strict scrutiny here. And the question I have, we're not a court of first review on this issue. Why don't we send it back? I'm assuming that the 3rd and the 9th didn't apply strict scrutiny because they thought they'd have a problem with applying it to this law. Why should we be breaking our normal pattern in this case?
Because there is ongoing harm every day. Ms. Chiles is being silenced, and the kids and families who want her help are unable to access it. It's very similar to what this court did last term in the Mahmood case, where the 2 lower courts had decided the case on rational basis review, and when this court decided that strict scrutiny was the proper
Remember,
analysis.
I dissented.
I do remember that, Justice Sotomayor.
Justice Kagan?
Do you think if there were the exact opposite kind of law, so this is a therapist that, consistent with the child's goals, is trying to get the child, to accept a gay identity or a trans identity. So it's exactly the same statute, but it's just flipped around. Same argument?
Strict scrutiny would apply to that unless there was conduct involved. If there was conduct and that conduct was unlawful, then the speech integral to unlawful conduct doctrine would apply. But if it's only speech, then yes.
Right. I'm assuming that your caveat, unless there was conduct involved, applies to your case as well, right? That applies symmetrically to both, unless there was conduct involved that was of that kind.
That's correct.
Okay. So symmetrical.
Correct.
Okay. What do you think? Suppose, you argue in your briefs that this law has viewpoint bias in it, and suppose that that was accepted. Do you think that we should stop there? Is there any reason at that point to go on to say how, in this particular context of medical treatment, we would treat a content-based law that is not viewpoint-based?
I really like Justice Kagan, which is quite surprising, being she's one of the traditionally more liberal judges or justices, that she is bringing up the reality that these bans are viewpoint discrimination. And so she has some really good questions in this regard.
I don't think the court needs to address that if it finds that this is viewpoint-based discrimination. It reminds me of the distinction between this court's decision in Brunetti and then in Vidal. In Brunetti, there was viewpoint discrimination, and then when just content discrimination was at issue, the court treated it differently.
Thank you.
Justice Gorsuch?
Just quickly, back to the late-breaking standing argument, which is in, I think, footnote 18 on page 23 of Colorado's brief, and what your client intends to do. As I read the verified complaint, she would, consistent with the patient's wishes, explore changes to not just attraction, behaviors, and expressions, but also identity. Is that correct?
That's correct.
Okay, so even under Colorado's new reading of the statute, which is only about identity and orientation and not about those other things, even though the statute includes them, even under Colorado's understanding, your client would still wish to counsel people in a way that contravenes Colorado's present understanding of the statute.
That's correct.
Thank you.
Justice Kavanaugh? Justice Barrett? Justice Jackson?
So, as I understand it, the First Amendment protects the communication of messages, expression, etc. Am I right about that? I mean, you're communicating, and that's what the First Amendment is about.
Correct.
So I guess I'm still just struggling with whether a therapist who is acting in their professional capacity to help someone achieve their goals is really expressing the kind of message or expressing a message for First Amendment purposes. I mean, I understand if Ms. Chiles here were writing an article about conversion therapy or writing or giving a speech about it. But it's just a little puzzling to me that she would stand in a different position than a medical professional who has exactly the same goals, exactly the same interests, and would just be prescribing medication for that rather than her talking with the client.
I don't think that they would have exactly the same goals.
Why not?
Because this involves a conversation.
Yes.
There is a back and forth. So this court has recognized many times in cases like McCullen that a one-on-one conversation is a form of speech. And that's exactly what's going on with Ms. Chiles and her clients. So when she engages in those conversations, she's encouraging them to achieve their goals. She's discussing concepts of identity and behavior and attractions and how they fit together. This is an ongoing active dialogue where she's helping them to explore their goals, and that absolutely has to be protected by the First Amendment.
And you're saying the similar kind of exchange doesn't occur with the provision of other medical services that don't involve talking?
It certainly might occur in other instances, but oftentimes there's conduct connected to it. That's what's different about the medical context.
And I'm sorry, can I just ask you again what Justice Sotomayor asked, which is why wouldn't we send this back if you're right about strict scrutiny?
Because
and let the lower courts apply that
Because
same.
there is irreparable harm going on right now. Ms. Chiles is being silenced. The kids and the families who want help, this kind of help that she'll offer are being left without any support.
No, I understand, but strict scrutiny is not necessarily fatal, right? We have cases in which strict scrutiny was applied and it was surmounted. So why wouldn't we give the lower courts a chance to evaluate whether there's sufficient evidence here for the state to actually go forward with this regulation?
Because we were arguing for strict scrutiny in the trial court, so Colorado knew that was our position, and they had an opportunity to make their record. But the evidence that they submitted and the expert materials undermine their case. The expert materials admit that they don't have any study addressing precisely what's at issue, or specifically focusing on precisely what's at issue here, which is voluntary conversations between a licensed professional and a minor. Their expert materials also recognize that they cannot prove harm. We've cataloged all the places in their expert materials on page 22 of our reply brief where they concede that. And lastly, their own own expert materials recognize that many people have experienced life-changing benefits from this kind of counseling.
Booyah! I love this James Campbell. He's bringing it right back to what the main point is. They cannot prove harm. They cannot deny that people have reported benefits and life-changing effects from good ethical therapy for exploring change in sexuality and gender.
Again, the APA's own report talks about how this helps people because they're able to align their life with their religion. They're able to find deeper relationships with God. They're able
Doesn't
to
Colorado have some evidence that conversion therapy more broadly is harmful? I mean, I think there are like 25 states or something who have similar laws. So someone has some evidence related to the harmfulness of this activity, right?
Colorado certainly cites studies, but those studies suffer from significant flaws. The main flaw in all of them is that they lump together dissimilar approaches. They treat voluntary conversations the same as shock therapy.
Thank you.
See how she cuts him off right? Thank you. She don't want to let him keep explaining all the problems with the rest of their so-called research on harm. But there was more he was going to say there. But at least he got that part in, that hey, the main issue is they lump together dissimilar approaches of voluntary talk therapy along with aversive techniques like electroshock. And you're going to tell us that what we do is harmful. So this will come up again later when the Colorado State's attorney gets up. But I'm really glad that he snuck in that point, and she set him up for it. She asked the question. I don't think she was ready for his answer.
Thank you, counsel.
Thank you.
Mr. Mooppan?
Mr. Chief Justice, and may it please the court.
Okay, this is really interesting. So we actually had the U.S. Solicitor General in our defense, on our side on this. So he's also arguing along with the Alliance Defending Freedom. So that's fascinating, that we had a representative of the federal Department of Justice advocating for client rights and therapeutic choice. Hey, elections matter.
Colorado's law is subject to strict scrutiny under the First Amendment for three straightforward reasons. First, the law restricts speech based on content and viewpoint. It prohibits petitioner from counseling minor clients to help change certain feelings and behaviors. It is thus subject to strict scrutiny unless an exception applies. Second, the law falls outside the exception for regulations of conduct that only incidentally burden speech. There is no separate non-speech conduct being regulated here. And professional medical treatment is not exempt from the ordinary First Amendment rule that strict scrutiny applies even to laws that generally regulate conduct, where those laws are triggered by the communicative content of speech. Third, the law falls outside any historically grounded exception. There is no longstanding tradition of states imposing this type of categorical prior restraint on the speech of therapists. I welcome this court's questions.
In the context of strict scrutiny, how strong evidence would Colorado have to show in order to prevail?
Well, in this case, Your Honor, Colorado has no evidence, so I think
I understand that, but hypothetically.
First, I love that they have no evidence. So, Justice Thomas, keeping him straight and being all business here. But oh boy, what a comment! I love that.
What would they have to show?
I think for this sort of sweeping categorical prior restraint, I think they would have to have very strong evidence that there was direct harm to patients, no countervailing benefit, along those lines before we could even talk about whether they can meet the very high standards of strict scrutiny. But again, this case is a much easier case because I think counsel will have to concede that if you look at the preliminary injunction record, both the three pieces of evidence that they put in, the Glass-Gold report, the 2009 APA report, and the 2015 SAMHSA report, and all the materials cited therein, none of them consider the type of speech at issue here. Speech by a licensed therapist involving non-aversive methods to minors. They just don't have any evidence of that. So certainly that's not enough under strict scrutiny.
This is exactly what I was talking about in my previous video, where I'm saying that even the APA itself, in their 2009 task force report, admits that there are no studies of sufficient rigor. According to them, there are studies out there that do show benefit and don't report harm, but they didn't want to admit it at that time. But to them, there was no studies of sufficient rigor on modern day forms of SOCI, sexual orientation change efforts. So they concluded there that there's not enough evidence to prove whether it is helpful or harmful, whether it is effective or ineffective, because there are no studies on current day forms of SOCI, because they're admitting there that the aversive techniques that they were talking about in earlier parts of the study aren't being done today. So it's pretty much a moot point when you talk about, how harmful so-called conversion therapy is, when you're talking about practices that haven't been done in 50 years or so. So I love that he brought this up.
How does your analysis change if there is an aspect of conduct involved?
So the same answer, Your Honor. I think that if there is conduct, then the question would be, is the restriction of speech incidental to the conduct, or the regulation of the conduct, or not? And this court hasn't drawn a particularly clear line about when speech is close enough to conduct to be viewed as incidental. But here again, this is an easy case because there is no conduct. All that is happening here is speech. Now, there have been a lot of questions about, well, what if it's medical treatment, or what if you had a general rule about standard of care? And this court's cases, in cases like Holder and Cohen, make clear that that is still speech. In Cohen, for example, breach of peace was a violation of the law. You could breach the peace in the courthouse in California in a lot of different ways.
Right, but neither Cohen nor Holder involved medical treatment, right?
No, so that's true, but that's just a label, and this court has also said that labels don't matter in cases like Bunning. There's nothing conceptually different. Take Holder, for example. In Holder, there was a statute that said, don't materially support terrorists. You can materially support terrorists in lots of different ways. You could give them money, you could give them guns, or, as in Holder, you could give them advice about how to commit their acts.
I understand, but when you look at the Tenth Circuit's opinion, they talk about how there is a long historical tradition of regulation of medical treatment as a particular thing. The provision of these kinds of therapies.
Right, and the problem is the level of generality. There was also a long historical tradition in this country of regulating contempt of court and breach of peace. But what there is not a long history and tradition in this country of doing is regulating contempt of court and breach of peace when it's purely based on speech. And if you look at the history that the other side cites here, what is totally absent is the regulation of medical treatment that consists solely of speech.
Does the federal government agree with Justice Kagan's flip side scenario? So it doesn't matter to you that we're talking about Mrs. Chiles' form of therapy versus gender-affirming care form of therapy?
We do, and in fact, we think that's a strong reason in support of our position. Colorado's position, I think, inevitably leads to the conclusion that all the states in Discrimination could have not only banned things like cross-sex hormones and prescription blockers, puberty blockers, but also therapy, talk therapy along the same lines. Even starker, in the 1970s, it was the standard of care, professional consensus, that being gay was a mental illness. So on their position, a state in the 1970s could have made it illegal for a therapist in the state to counsel a gay patient that they weren't mentally ill.
It's a weird example, but I'm glad you brought it up, because we are simply looking for therapeutic choice. We're not looking that gay affirmative therapy be banned and that all clients of same-sex attraction be told that, oh, you have a mental disorder because you have SSA, and that people be forced to do so-called conversion therapy or change allowing or change exploring therapy. We just want to protect the clients to have the therapy for their unwanted same-sex attraction or gender identity confusion that aligns with their values. It's not that hard. It's pretty simple, pretty easy request.
That just cannot be right under the First
Can you
Amendment.
address Justice Sotomayor's question from before about whether we should apply strict scrutiny, assuming we think it applies here, or remand it to the 10th Circuit to do so? What does the United States want to say about that?
So you could remand, but we think, like in Mahmoud, this is a case where it would be probably fairly appropriate to actually just resolve the case here.
Why?
And for two reasons. One is there is ongoing irreparable harm to the petitioner because of the restriction of their speech. And the second is the evidentiary record here is totally clear that they can't satisfy strict scrutiny. If you look at the record on what's in the preliminary injunction record, there is just no evidence that this type of speech, not aversive therapy, not speech by non-licensed professionals, not speech to adults, but speech to minors by licensed therapists.
Do you have just last question from me? Standing, what's your position on the late-breaking standing argument?
So precisely because it's late breaking, first of all, I think the most important thing is it's mootness, not standing. The question is whether there was a credible threat of enforcement for standing purposes. There clearly was, because as counsel said, if you match up paragraph 87 of the complaint with the statute, the conduct that petitioner wanted to engage in is clearly covered by the plain text of the statute. So, at most we're talking about mootness because the government has come in now and suggested that somehow the plain text of the statute doesn't apply, or they're not going to enforce the statute despite that. And we don't think that in these circumstances, when the state comes in post certiorari and advances a fairly implausible reading of their statute, that that should be enough to defeat standing. If I could say one more thing about how implausible their reading is.
Okay, you gotta strap yourself in for this example, because there's a brilliant point he makes. All right, listen carefully to what he says.
As I understand their position, it seems to be that the language after including isn't independently sufficient. You have to be trying to change behavior orientation independently. If that was true, it would equally apply to aversive therapy. So if someone went into a therapist's office and said, I don't want to be gay anymore, I don't want to engage in same-sex conduct, if the therapist said, look, I can't change your orientation, but I can try to change your behavior, and I'm going to use electroshock therapy. According to the state, as I understand their position, they seem to be saying that that's not covered by their statute. I find that awfully hard to believe, and that just sort of underscores how implausible their reading of the statute is, and perhaps why it showed up on footnote 18 after the court granted cert.
And I find that hard to believe as well, but if they're going to stick to their guns on this idea that, oh, this is what we're really meant by that clause or that including section of the statute, then you could make that conclusion. And in fact, some of the amicus briefs written in support of Colorado's ban try to appeal to the court to actually get rid of this section saying that they ban behavior, attempts to change the behavior. So just keep it so that you can't change someone's orientation. Like, we're fine with the ban as long as the ban is to against changing attempts to change the orientation. But you should allow therapists to help with clients who want to change the behavior. Well, then his example, as far-fetched as it might sound to us, could actually be reality. I mean, there aren't any therapists using aversive techniques out there, but it would certainly open the door to that if they wanted to. And they could say, well, you know, I'm just working on the behavior, so I'm using a strictly behaviorist approach that may include aversive techniques. I'm not worried about the actual orientation as long as I don't act on it afterwards. Yeah, okay. That's what they open themselves up to if they are really trying to stick with their reinterpretation of the clearly stated law.
Thank you, counsel. Justice Thomas, anything further? Justice Alito?
If we thought that this statute engages in viewpoint discrimination, does that have a bearing on whether we should decide whether it satisfies the applicable constitutional standard or remand the case?
I think it makes it even clearer why it fails strict scrutiny, but I think even as a content-based restriction, it pretty clearly fails strict scrutiny.
Thank you.
Justice Sotomayor?
We keep going back to the question of the studies and what's the strongest list tick off. The thing that gives me pause in not applying strict scrutiny or in applying it is that none of the studies say that talk therapy is harmful. Is that correct? And Colorado
for this type, for talk therapy by a licensed therapist to minors. They don't have any studies that say that that is either harmful or ineffective. And indeed, they often concede that they don't have that. The 2009 APA report expressly acknowledges, at pages JA 221 and 256, expressly acknowledges that they don't have evidence of that. And if you look at the Glasgow Declaration, which is after 2009, she too doesn't cite anything. If you look at the studies that she cites in her declaration, all of them are conflating either aversive and non-aversive, or licensed and non-licensed, or minors or adults. They just don't have anything. And this comes up to the court after a PI hearing. And if the strict scrutiny applies, they bore the burden, and they just don't have anything.
Yeah, the 2009 APA Task Force report specifically says there is a lack, they really should say a complete absence, of studies on so-called SOCI on minors, in particular like modern day SOCI. And that has not changed, because they also say there's no training programs on how to do SOCI, which wasn't true, because the Alliance, or the NARTH, had been training therapists for years on how to do appropriate ethical therapy for exploring same-sex attraction issues. But they denied that there's actually sufficient training on how to do sexual orientation change efforts therapy. But also, they made the recommendation, and every grad school will tell you that no, you're not allowed to practice this. So of course there's not going to be any studies when the psychological community at large forbids it, and they're not going to teach you techniques for this in graduate school. You have to go beyond it to be pretty gutsy and courageous to seek out training by therapists like myself in how to help clients, adult or minor, in exploring change in their sexuality. So few people are brave enough to do that. So there was no evidence back when they made the 2009 Task Force report, and there's no evidence today, because they've yet to study this when it comes to minors. There are studies that show, most of them retrospective, show both harm and benefit, or effectiveness and ineffectiveness when it comes to adults doing therapy, but there have been zero studies when it comes to minors. And so really these bans were based off of a complete lack of evidence for the very thing that the bans are about.
Thank you.
Justice Kagan?
Mr. Mooppan, you have an evocative example in your brief which I want to pick up on, which is, let's say there's a school of psychotherapists that think that the best way to deal with suicidal patients is to go dare them to commit suicide. And you basically say, yes, strict scrutiny applies, but don't worry, it could be satisfied in a case like that. And I just want you to run through that and tell me why you think strict scrutiny applies, and why you're confident that it could come out the way you think.
I'll be honest, I had to look up terms here. Strict scrutiny, and the way that they're using the term was confusing even after I looked up the definition. So it's legalese. You have to be real familiar with legal terms to really make it through a lot of this conversation here, especially over the idea of strict scrutiny and standing, and whether or not they should pass this back down to the lower courts and let them make the decision and keep their hands clean for this whole thing. So maybe someone in the comments section, it'd be good if I had a lawyer on here to discuss this a little bit more. To me, though, this is really a red herring. This whole discussion of strict scrutiny is really not getting to the core of our arguments. It's just a way to see if we can play hot potato. Just see who should really make the decision. Should it be us or a lower court? And I'm not really interested in this. So pardon me if I skip some portions of this back and forth about strict scrutiny.
Justice Jackson?
Can I ask you about licensing? You talked a lot about malpractice, but don't states tend to tie licensing requirements to the standard of care? And so if we had a situation like this in which a state licensing board disciplined a doctor for a speech-based practice outside of the standard of care, would that doctor have a First Amendment defense?
Okay, now we're getting into the discussion of standard of care, and our alarm bell should be going off. especially after the scandal of WPATH, the World Professional Association for Transgender Health, and the WPATH papers and the Cass report showing the sort of the rigging of the standards of care. And so standards of care aren't always standards. What we refer to as standards of care sometimes are just simply top-down edicts, and they exist within an ideological vacuum. So they are not informed by the full consensus of all clinicians who are treating people with this particular issue. So the best example of this, of course, is when it comes to issues of gender identity confusion or gender dysphoria. For years, we've been told, oh, the standards of care were, they have to live as the opposite sex for a few years, and then, just socially and with the way they dress and the way they express their gender, and then they can start with cross-sex hormones, and then they can, after so much time doing that, they can look into some form of surgery, and that was a standard of care. But that really was just recommendations from a particular organization. And the organization that made those standards of care, WPATH, would revise their standards of care, not based on emerging research or really a preponderance of evidence about which approach is best, but really based on what their ideological agenda is. And it was to more and more make transgender identification normalized and to make access to treatments easier and earlier, so that children can start to go through the process of transition prior to puberty and to avoid their bodies transforming according to their natural sex, and so the later operations and procedures don't have as many obstacles to make them appear more and more like the opposite sex. And so they kept rigging the standards of care, and yet they weren't based on whether or not their approaches are actually helping people resolve their real complaint about the dissatisfaction with the reality of their bodies and their gender, their actual sex. So eventually this all got exposed, and people started to see the emperor has no clothes when it comes to what WPATH's so-called standards of care. Well, the same thing should also be applied to our understanding of standards of care when it comes to unwanted same-sex attraction. There's a wide range of opinions on what the standard of care should be for a client who comes to a therapist's office and says, I have unwanted same-sex attraction. It is not in alignment with how I view myself and with my values, my sincerely held religious values, or just simply my own values as a person. That I believe men should be with women and women with men, and that I support natural marriage and natural parenting, and so I want to get to that place where I can experience that, where I can engage romantically and sexually with someone of the opposite sex, and these same-sex attractions are interfering with that, and I'm also engaging in pornography and acting out of a homosexual nature, and I would like to stop that. What's the standard of care for that? Well, if we go based off the ethical principles of client self-determination, it's quite obvious. You should help the client with their goals. But APA and the task force report, and later just influencing all the other organizations like the ACA and the NASW, are all saying, no, you have to override the client's goal and tell them, no, we can't do that sort of therapy. We cannot help you. We cannot use our clinical training to assist you with your goals because of the myth of it being harmful to pursue that as a goal and ineffective. So we're going to not have a predetermined goal. Reality is they're going to influence them toward LGBTQ plus identification and full embrace. And so there's been an imposition of a so-called standard of care that's being imposed on all clinicians, starting with in graduate school and on through. that's not real standard of care, because there's been no minority report, there's no like actual discussion on this so that those with differing opinions can have their voices heard, and clients who are actually seeking out this sort of therapy can be respected. No. It's all been top-down, authoritarian. That does not tell us what the real standards of care are, because it's not taking into account those who differ in worldview from the prevailing narrative.
So there is a long history and tradition in this country of licensing, and even licensing for people who engage in speech. What there isn't a long history and tradition of is, as a condition of that license, imposing a prior restraint on the types of speech they engage in. And we know from NIFLA that the mere fact that there's a license isn't enough to obviate First Amendment review. Obviously, the whole point of NIFLA, it was regulating.
But NIFLA was a notice scenario, right? It wasn't,
for a licensed clinic.
No, I understand, but it wasn't connected to the provision of services to particular people. That was part of the analysis. And so I guess what I'm saying is a doctor who's providing services pursuant to a state license, I'm just trying to understand how the First Amendment protects that doctor from providing therapy that is outside the standard of care.
Well, because in NIFLA itself, the court made clear that part of the reason it was rejecting a professional speech exception is because it was very worried about the risks of the state interfering with the doctor-patient discourse. And it gave as an example how in certain authoritarian governments, they do things like tell doctors you can't tell patients about birth control. Those people are all licensed. And so if there was some sort of argument that because you're licensed, all of a sudden the state could tell you what to say and what not to say to your patients, those very harms, the precise harms that NIFLA pointed to, could happen.
Can I ask you just one final question, just sort of from a very broad perspective? I'm wondering why this regulation at issue here isn't really just the functional equivalent of Scrimetti. I mean, I realize that there were two different constitutional provisions at issue, but the regulations work in basically the same way, and the question of scrutiny applies in both contexts. So it just seems odd to me that we might have a different result here.
This is the same argument that a psychologist made at a conference I was at, where he was trying to say, hey, you Christians looking to advocate for what you call what he called conversion therapy, states are banning you from doing that therapy, but you Christians are coming against the LGBTQ by banning gender affirming care. So let's call it even. And this sort of equivocating is basically what Ketanji Brown Jackson is getting into here. That, well, with Scrimetti, that was, I think it was about Tennessee's law that they were passing to outlaw and ban transitioning minors, doing medically transitioning minors. And she's saying, well, how is this any different from that? You guys want the clinicians to have the freedom to do treatment, but yet you also wanted to have laws that outlawed a particular type of treatment. Well, because one is clearly different from the other. We're talking about just speech, just talking with a client. You're going to outlaw speech with the client, but then you're going to fight to allow a conduct that is radically life-altering by nature. Like, speech can be life-altering, certainly, depending on how the client responds to the speech. But when you chop off body parts, when you inject the wrong degrees of the opposite sex hormones in someone, when you block the natural process of puberty, then you are innately doing something life-altering, not to mention harmful. So the states did have not just a right, but a duty to protect minors in those situations by outlawing gender-affirming care, this stupid euphemism they're using now, and prevent them from going through this process that is damaging them and sterilizing a whole generation of kids who are trapped in this gender deception. How does that compare to us just talking with clients, exploring things at a more intellectual and conversational level? It doesn't.
Well, Discrimination was a law that regulated on the basis of age and medical treatment.
No, but here's what I mean, right? In Discrimination, we had a state that wanted to prohibit certain medical treatment, gender-affirming care, being given to minors in the form of medication. And we said that was okay, and I understand there are particulars with respect to how the arguments, the constitutional arguments worked, but the state can prohibit that. Here we have a state that wants to prohibit gender-related medical treatment in the form of talk therapy, but we now have the First Amendment that is inhibiting the state's ability to do that. And I'm just, from a very, very broad perspective, concerned about making sure that we have equivalence with respect to these things.
Well, from a very broad perspective, there shouldn't be equivalence because obviously
Okay.
we have a First Amendment. So when you
Because
have treatment
talk
involves
therapy,
speech,
the speech is what is at the core for you. It's
Right.
not necessarily the state's interest in protecting minors from what it believes to be certain harmful
Right.
treatments.
just like in Holder, the state had a very compelling interest in stopping material support of terrorism.
Right.
But when you stop terrorism through speech versus from conduct, the analysis is
Got it.
different.
All right, thank you.
Thank you, counsel.
Okay, now we're going to hear from Colorado State's attorney.
Ms. Stevenson?
Mr. Chief Justice, and may it please the court. Throughout its history, this court has recognized that state power is at its apex when it regulates to ensure safety in the healthcare professions. Colorado's law lies at the bullseye center of this protection because it prohibits licensed professionals from performing one specific treatment because that treatment does not work and carries great risk of harm. No court has ever held that a law like this implicates the First Amendment, and for good reason. First, the law applies only to treatments. That is, only when a licensed professional is delivering clinical care to an individual patient. In that setting, providers have a duty to act in their patient's best interest and according to their professional standards. The First Amendment affords no exception. Second, because this law governs only treatments, it does not interfere with any First Amendment interest. It does not stop a professional from expressing any viewpoint about that treatment to their patient or to anyone else. And because Colorado's law regulates treatments only, and because it enforces the professional standard of care, the law falls squarely into the reasonable regulation of professional conduct that does not trigger First Amendment scrutiny. Petitioner's argument, on the other hand, cannot be reconciled with history, precedent, or common sense. A state cannot lose its power to regulate the very professionals that it licenses just because they are using words. A healthcare provider cannot be free to violate the standard of care just because they are using words. And a state cannot be required to let its vulnerable young people waste their time and money on an ineffective, harmful treatment just because that treatment is delivered through words.
What treatment? What specifically? What treatment? Anyway, let me let her finish. She's pretty much at the end there, but there are a lot of points I want to jump in there and argue with her. But I want to wait for her to finish her whole statement, but I had to jump in with that.
Petitioner asked you to enjoin a bipartisan law passed by 25 different states, but she did not put one single piece of evidence into the record. Not a single expert, not a single study, not a single mental health professional willing to endorse conversion therapy. And there is a mountain of evidence to the contrary. On this record, we request that you affirm the denial of preliminary injunction. I welcome your questions.
Not a single expert, not a single professional willing to endorse conversion therapy. Well, one, we don't use the term conversion therapy, so we would never endorse conversion therapy. We do endorse change exploring therapy or change allowing therapy or safety, sexual attraction, fluidity exploration in therapy, or gender exploring therapy. So we have other terms we would use. So we would not ever say we endorse conversion therapy. But in support of Kaley Chiles, we had 52 amicus briefs submitted. So, yes, she certainly had experts and clinicians in this field offering their support. And these were people like Joe Nicolosi Jr., Reintegrative Therapy Association, myself and my colleagues from the Alliance for Therapeutic Choice and Scientific Integrity, the International Foundation for Therapeutic and Counseling Choice, and numerous other independent therapists and clinicians and former clients, different professionals who've benefited from therapy, submitted their own amicus briefs. So, yes, plenty of people did come forward. In fact, 52. Whereas in support of Colorado's ban, they received 30 amicus briefs. So we had 22 more, a huge margin more than those in support. So there's actually people showed up overwhelmingly in support of getting rid of these bans. So I don't know where she must have written this way in advance or something and didn't do her research.
If petitioner were a non-therapist, would this be protected speech?
Well, so I wanted to mention our law covers physicians as well. They are also subject to the conversion therapy ban. But if you're talking about a non-professional, I think it would. Our argument is premised on the notion that there is a special relationship between a healthcare provider and a patient, where that patient is in a position of vulnerability and dependency on the healthcare provider, and the healthcare provider owes fiduciary duties to act in that patient's best interest only.
In Colorado, are there only healthcare providers who provide this sort of service?
No, the law accepts, I don't know factually if there are, but the law exempts religious ministers and ministries from this, and there is also a group of people called life coaches who could perform this therapy.
So what exactly transforms speech in that context to speech that is protected in that context to speech that is not in the therapist context?
It is the relationship between a healthcare provider and the patient that establishes this special context. And again, if you go to a life coach or you go to someone else, they're not licensed by the state. You're not expecting them to be complying with standards of care. You have a different expectation. When you're going to see a licensed healthcare professional who owes you fiduciary duties, your expectations are different. You're expecting information that is complying with the standard of care, and not expecting the practitioner to just be exercising their right to say whatever they want to say. And that's just materially different, and it's always been treated so.
So what if someone who happened to be devoutly religious and actually relied more on the minister than the therapist? It seemed that person would be equally dangerous.
Well, I think that would be a personal choice that they were making to rely on their religious minister. It wouldn't be a representation from the state that this is a licensed professional who we are holding to a certain standard of care. And so the expectation, at least vis-a-vis the state license, would matter a lot. And in addition, the religious minister, just as a legal matter, doesn't owe fiduciary duties in the same way that a healthcare practitioner does.
So in other words, Colorado is admitting that this ban only applies to licensed clinicians, those licensed by the state, and they can't apply this ban to those who are operating without a license, like life coaches or ministries or pastors. But don't doubt for a second that if they can find a way to apply these bans to those individuals as well, they will. They tried it in California back in 2018 with the AB 2943. They pulled it last minute when they got all the ex-LGBT people coming forward and starting the change movement, and they are looking for ways to outlaw any form of counseling for non-licensed counselors and help as well, which is what we're seeing in other countries, like in Canada. Doesn't matter if you're licensed or unlicensed. Anything that they consider so-called conversion therapy will get you either fined or imprisoned. Not just Canada, but Victoria, Australia, France, other countries. It doesn't matter. We have such a separation of church and state here in the U.S. that so far this stuff only applies to state-licensed clinicians. But if they could, the activists will try to find a way to prohibit even Christian counselors and pastors from doing this type of work. And because everyone's so terrified of being called a conversion therapist, there's a chilling effect even among pastors and ministers. Everyone's so scared to be called a conversion therapist, and so they'll just do sort of supportive counseling and so-called sexual identity therapy and just helping people with guiding them toward acceptance and figuring out how to live with their orientation as well as be in their faith, and not really do anything to help them explore the root issues and find greater levels of integration and maturation sexually. So, yeah, there's a chilling effect even among non-clinicians, sadly.
Counsel, you said, just because they're using words, but our cases separate those out. Holder, NIFLA, in other words, just because they're engaged in conduct doesn't mean that their words aren't protected.
So, Chief Justice, our case is absolutely premised on the notion that communications that are happening in the very specific context of treatment, which I will call a licensed professional delivering clinical care to an individual patient, where they are subject to fiduciary duties and subject to malpractice, that is fundamentally different, a fundamentally different regulation than a regulation of people out in the world going about their business, like at issue in Holder, where you have generally applicable statutes that apply to everyone. This is just a fundamentally different relationship. It has always been treated like that. In NIFLA, the court talked about the fact that longstanding torts for malpractice did not implicate heightened First Amendment scrutiny, and I think that analysis is exactly the same here. Malpractice, you're dealing with that same individualized relationship, and this is the exact same context.
Ms. Stevenson, I want to ask you what Justice Kagan called the mirror image question, and Mr. Mooppan and Judge Hartz's example about homosexuality in the 1970s was professionally considered to be a mental health disorder. What if a state back then might have passed a law prohibiting talk therapy that affirmed homosexuality? Would that be subject to rational basis review on your theory?
So, Your Honor, what our theory depends on is that there is a treatment being provided that's being regulated, and that the regulation is consistent with the standard of care.
Let's check both of those boxes in our hypothetical.
Then yes, and I want to return to Justice Jackson's point, because
so yes,
they could regulate.
The state could forbid a regulated licensed professional from affirming homosexuality if that were consistent with the then prevailing standard of care.
That's right.
And so likewise, if the prevailing standard of care were to change or to solidify that this sort of talk therapy is beneficial to minors, or at least not harmful to minors, then a state could pass a mirror image statute to Colorado's that prohibits any attempt to affirm changes of gender identity or sexual orientation, and that would be subject to mere rational basis review on your theory.
That's right.
In other words, what he's bringing up is that the standards of care have changed over the years. And if you study the history of homosexuality being removed from the DSM, it was not because there was some new evidence and research that overwhelmingly showed that this is no longer a disorder. It was just a change in philosophy, and most of it under duress because of gay activism at APA meetings. So the standards of care are highly vulnerable to ideology, to political pressure. So he's making a bit of a point here.
Your Honor, and just to illustrate, it's not, the fact that there are words involved doesn't make it different. So states, like we recognized in Discrimination, have the power to regulate even in the face of medical uncertainty. The laws or the standard of care could change there, and the legislature can act to change that. And
so even in cases where medical uncertainty exists, you think that the state could pass such a law prohibiting ex ante speech that would affirm gender identity changes or sexual orientation changes or homosexuality?
I don't think you have to reach that question in this case, because
I'm asking about the logic of your argument. I think you just said states can regulate even in the absence of medical consensus in this fashion. Is that right?
Where there are no words involved and no First Amendment issue raised. And
I'm asking, we're talking about speech and we're talking about therapy, talk therapy. That's what I want to get at. And I think you're saying that if there's medical consensus, states surely could pass mirror image laws. And I think you're saying, but I want to make sure, that even in cases where there's medical uncertainty, the state could so regulate.
You could reach a holding in this case that said, yes, treatment is treatment, and this can be, it doesn't matter whether it's consistent with the standard of care or not. We would urge you to reach a narrower holding in this case.
I understand that, but I'm asking you to answer my question. Could a state, when there's medical uncertainty, and we normally provide, this court has many times said, when there's medical uncertainty, we defer to state judgments. And I think you're saying that yes, I think the logic of your position has to be yes, and I'll let you go as soon as you give me an answer up or down on the state of medical uncertainty and whether they could pass mirror image laws.
I think it's less clear that that fits into the historical tradition identified in NIFLA that calls specifically out malpractice, which is an enforcement of the standard of care. And while that question could come up in another day here, where we meet the standard of care, we don't think we need to reach it.
Counsel, it's pretty important, though, to think about how this would apply to cases down the road. So let me describe medical uncertainty as competing medical views. And let's say that you have some medical experts that think gender-affirming care is dangerous to children, and some that say that this kind of conversion talk therapy is dangerous. Can a state pick a side? So it's not, I want to be very clear, it's not that the medical community says, we just don't know. It's that there are competing strands. And some states, like say Tennessee, which was the state at issue in Discrimination, pick one side, Colorado picks another side.
Thank you, Amy Coney Barrett. She's really getting to the heart of the matter here. There's not a clear standard of care when you have differing medical opinions and differing psychological opinions from experts on this topic. And so, can the state weigh in favoring one side or the other?
Your position is that rational basis applies?
Our position in this case is that the standard of care is important. It's important because that's been the historical
But like Justice
tradition.
Gorsuch said, just answer that question.
No, our view is that would not be the right rule here. One, because that's not consistent with the history and tradition identified in NIFLA. And two, because the reason why that history is important and the reason why the standard of care is important is because it's a confirmation that the state is not actually trying to shut down.
Okay, I'm not understanding the why
viewpoints.
the standard of care. Tell me. I mean, maybe I'm not following you. Are you saying that the standard of care? Why do you think the standard of care question isn't relevant there? Because wouldn't that be a situation in which Colorado is essentially saying that the standard of care, that we're essentially looking at expert evidence and saying that we think this is what's appropriate, that we shouldn't have this kind of talk therapy, and Tennessee's choosing a different one as a matter of its state law? Or am I not understanding that correctly?
What I'm saying is where there is a First Amendment issue raised and the state can show we're regulating a treatment and we're regulating consistent with the standard of care, there is a confirmation, a security that the court can have that there is no other motive going on to suppress viewpoints or expression. And that's what's consistent with...
So Colorado's law would trigger a rational basis, but Tennessee's hypothetical law would be strict scrutiny.
If it were against the standard of care.
So there's no mirror image.
Counsel,
rule,
can you define
Justice Kagan?
standard of care to help us? Is the standard of care a medical consensus about what should happen in the situation?
Let's define standard of care. Is it the consensus? Shannon Stevenson says yes, but how is there consensus when we're not being brought to the table? All the dissenting psychologists and psychotherapists in this field, we don't have a voice in the APA or the ACA. They won't hear us. Look at the APA task force that they did back in 2009. You had Dr. Nicolosi, Mark Yarhouse, Stanton Jones, Dean Bird, all these people who are well versed in the subject, who were nominated to be a part of that task force, and they were prohibited. And the APA's head of the Lesbian, Gay, and Bisexual Concerns Office, Clinton Anderson, said this in response to them rejecting all those applicants to be part of the task force. Quote, "We cannot take into account what are fundamentally negative religious perceptions of homosexuality. They don't fit into our world view." Unquote. So right there you're seeing the viewpoint discrimination within the APA. So you're not getting a true consensus. You're getting a top-down, authoritarian, this is enforcement of a worldview that leaves out not just dissenting clinicians, but dissenting clients.
It's the same standard of care that would apply in a malpractice case. Yes, that is how.
So it's not a situation in which you have competing doctors and there isn't a consensus on what is supposed to happen.
Correct.
No,
so
but I
you're
think you could have that. In my hypothetical, I'm saying that there might be a dispute in the medical community, is my hypothetical, where you have some experts saying that this should be the standard of care and others saying something different. That was the hypothetical.
Well, the question would be, is the regulation enforcing the existing standard of care? And you're describing a situation where it sounds like there would be many viable options under a standard of care?
Yeah.
Right. And so in that instance, I think that would raise more significant questions if there were actual multiple procedures, treatments available that all met the standard of care.
And there are. In an APA journal, Dr. Christopher Rossick, one of my colleagues at the Alliance for Therapeutic Choice and Scientific Integrity, and also one of our past presidents, he submitted a paper and was published in an APA journal describing there are 3 main approaches for individuals with a conflict over their same-sex attractions and their faith. They can obtain gay affirmative therapy, they can do change exploring or change-oriented therapy, or they could do sexual identity therapy. So there are 3 options that should be considered viable options available to clients. And that was published in an APA journal.
And again, this is just a question that would be resolved exactly the same as it would be in a malpractice case, where you could have, competing experts as well, and we'll decide, is this thing inside or outside the standard of care? If petitioner could put on an expert to show conversion therapy is inside the standard of care, then I think we wouldn't be here. That would be a different standard to apply to our law.
I have a question about how you're distinguishing Holder. It was a generalized law against providing material support to terrorists, but you seem to be suggesting that if there was a Bar Association rule that said it's a breach of your duty as a lawyer if you tell terrorists how they can break the law, that would be subject to rational basis review.
So I think that, again, the critical aspect of the relationship is that there is a duty between the professional and the receiver of the professional services. And it sounds like in the law that you're describing, Justice Sotomayor, there would be, the law is passed for some other interest than to protect the client in that case. And I think that's materially different. When we're talking about a special relationship where the client is depending on the expertise and training of the lawyer.
But I'm just not sure why that makes a difference. If we're talking about the speech aspects of it, why that becomes any less protected.
It's because that's how we've always treated speech between, especially in the healthcare context, between providers and patients. This has been an area that has been heavily regulated from the beginning of our country, and no one has ever suggested that a doctor has a First Amendment defense to say the wrong advice to their patient. And just to give an example on this speech conduct distinction, if I went to my doctor and had high cholesterol, she could tell me a number of things. She could say, come back next year. She could say, eat less red meat. She could say, I'm going to prescribe you a statin. Or she could say, you need an arterial stent. And whichever way she violated the standard of care and making a wrong judgment there could be equally harmful to me. And so I don't see how you can parse out whether there is conduct involved in terms of when you're talking about professional services delivered in a fiduciary relationship where the client or the patient is expecting accurate information and information delivered to benefit their health.
I don't really see a difference between the argument that you're making now and the argument that I thought we rejected in NIFLA, that professional speech is a special category that's outside normal First Amendment scrutiny. But let me put that aside and ask about your interpretation of the statute at this stage in the litigation. And let me give you this example. Suppose an adolescent male comes to a licensed therapist and says he's attracted to other males but feels uneasy and guilty about those feelings, and he wants to end or lessen them and asks for the therapist's help in doing so. Under your interpretation of the statute, is that banned?
So, Your Honor, our interpretation of the statute turns entirely on whether the purpose of the therapy is to change the person's sexual orientation or gender identity.
What is sexual orientation? Like, if you guys define sexual orientation as the direction of one's sexual attractions, then to go to a therapist to help lessen the attractions that the client finds disturbing would be considered changing the so-called orientation. So she's kind of trying to obfuscate or skirt around the issue, but this is the core of what we're talking about. Clients are disturbed by their attractions. You could call it an orientation all you want, or not call it an orientation, but what they're really coming to help with, to the therapist for help for, is, can you reduce these attractions that I don't want? And is there anything we do to help me cope with the attractions that remain? Can you help me with my tendency toward behavior that I don't want to continue engaging in? That's really at the core of the whole issue.
If that
What is the answer to my question? Is that banned or is it not banned?
If the therapist told him, or he asked, can you help me become straight? The answer would be it would be banned. If it was, can you help me cope with my feelings as to how I am and how I want to live my life? That's permitted.
I call bullcrap on that. Because, as everyone knows, all these conversion therapy bans, when they list what their definition of conversion therapy is, it's not about categorical change. It's any change. Any attempt to change, not just the so-called orientation, but the feelings, the ideation, the identity, the behaviors. So Ian Weiss said, well, I'm just here to help you cope with it, and part of coping it may be exploring ways to help reduce the intensity or the frequency of your same-sex attraction experiences. That is sufficient to qualify for their ban, because they use such a broad understanding of so-called sexual orientation. So right now in front of the court, she's trying to say, no, that would be allowed because just helping them cope. But if they're trying to change the orientation, as if that's a real thing, then it would be prohibited.
And all of that comes
why doesn't the situation that I've just described fall squarely within the terms of the statute, which says that conversion therapy includes, quote, efforts to eliminate or reduce sexual or romantic attraction or feelings toward individuals of the same sex.
If those things are undertaken with the purpose of changing orientation or identity, then they violate the statute.
That's not what your statute says.
This is the way we've interpreted the statute from the beginning of this case. It's the way both of the lower courts interpreted the statute. It's the way every state that has this statute interprets it.
Well, if you're going to interpret the statute differently from how it's worded, then repeal the statute and reword it. At least be accurate, so that anyone could read it and be like, oh, okay, I understand what this means. But no, you intentionally worded it in such a broad way in order to cause the chilling effect that you guys are also denying happening. So people are scared. I don't know. Am what I'm doing falling under the statute? I don't know. Okay, because guess what? The reality is no one is out there saying, I'll change you from gay to straight. Yeah, we do gay to straight conversion therapy. By the end of our therapy, you'll be straight. No one is out there saying that. So your whole definition of your statute is really a nothing burger. If you're only banning therapy for the therapist saying, we'll change you from gay to straight. These are therapeutic techniques to do that. Well, then you don't even need the statute because no one's out there doing that. But they are out there helping people with, let's explore the roots of the same-sex attraction. Let's help with the behavior, helping you live more chastely in alignment with your values. Let's see if we can explore some techniques that may have an impact on the intensity and the frequency of the attractions. Maybe explore your potential for heterosexual attractions and behaviors. Like, that's what's actually happening in therapy offices for those who actually do change exploring therapy, or safety, what you all want to call conversion therapy. They're not there saying, we'll change you from gay to straight. we're going to make you totally heterosexual. You're not going to have a trace of homosexuality in you anymore. All right, this is a myth, a complete fiction. Why go through all the trouble of creating a statute for something that no one is doing?
And the reason why is because the harms from conversion therapy come from when you tell a young person, you can change this innate thing about yourself.
Ding, ding, ding. Innate thing about yourself. So you see right there, that loaded language. You can change this innate thing about yourself. Who says it's innate? This is the worldview of the pro-LGBT activists, saying that your sexual orientation is something innate. And therefore, if it's innate, it's immutable, it cannot change, so to attempt changing it in any way would be harmful and ineffective. Their whole argument rests on the myth of it being something innate, when there's no actual proof of that innateness argument. People develop their attractions. They might come naturally. Obviously no one chooses their attractions, so let's not make a false dichotomy argument here that it's either chosen or you're born with it. They develop through experiences, through lack of certain experiences, through the unintended consequences of certain choices or experiences imposed on someone. But they develop, okay? What arouses you, where your desires are directed toward, are things that develop through the lifespan. It's not innate. But she's loading that term in there to make it sound like any attempt then to change would be as ludicrous as trying to change someone's innate skin color, innate ethnicity. That's essentially the argument that the pro-LGBT has been relying on.
And they try and they try and they fail, and then they have shame and they're miserable, and then it ruins their relationships with their family or...
Well, I know, I understand.
This is where the harm comes from.
That's a major hypothetical. I've worked with plenty of clients. Not all of them experience the degree of change that they would like. Some do, some don't. But they all come into my therapy with the understanding my attractions may not change. They understand. We're going to explore the potential for change. We'll see. Can't guarantee an outcome. But it's worth a shot exploring. Let's just at least do the work of exploring what's underneath the attractions, and let's just focus on that. Let's focus on reprocessing memories and working on emotion regulation and growing in your assertiveness and in meeting your needs in healthy ways. If the attractions change as a byproduct, we will expect it to happen only as a byproduct and to happen on a continuum, not categorical. None of us are speaking this or sort of language of a categorical change from one so-called orientation to the other. So even in cases where they don't achieve the level of change in their attractions and even behavior that they would have liked, I don't know of clients who are that distressed over not experiencing that degree of change. The ones who typically are more distressed are those who are maybe coerced into therapy by their family, and so their acceptance in their family is contingent on them changing, and so they might have more distress. And so we are very adamant about making sure the client is in agreement. Even when they're a minor, we get informed consent. So this hypothetical she has that this is what is causing harm is really just that, a hypothetical. There's a variety of other reasons to explain some of the pathology that we see among those who have gone through so-called conversion therapy efforts or associate efforts or change exploring therapy efforts. Oftentimes because they already have pre-existing pathologies, and these are the people who are the most distressed, not just about their attractions, but because of trauma, addiction, relationship conflicts. And the therapy is just trying to help them on a variety of issues, and they may not reach the level of change that they want, so they're still distressed afterwards. But we don't want to talk about that. We have to blame therapy for everything, not just the client's current lifestyle or their history of trauma that she's going to soon deny is a possible contributor to their SSA. So
And so if they're
I understand all of those arguments. What I don't understand is how you can square your interpretation with the plain meaning of the statute. Are you suggesting that everything beginning with the word including is irrelevant? That you just want all of that deleted from the statute?
I love that he says that.
No, it's illustrative. And so, for example, one of the ways that people try to engage in conversion therapy would be by saying, look, you need to start dressing like a boy, and then that will make you change your gender identity. That's a way you could go about that.
Who says that? Like, she's coming with some weird examples. It's like she never actually spoke to a therapist in her life who actually does this type of therapy she's trying to ban. I know that's the case. All these people who oppose our work, they don't actually speak to us. They don't actually have any interest in what actually happens in the therapist's office, about the work we're actually doing with clients, how we would address the client's goals. So she's saying this is illustrative, and then she uses some scenario that that sounds kind of ill-informed. But not like there's anything harmful, okay? So the client's coming to me with distress about their gender dysphoria. Like, do I even need to tell them to wear clothes consistent with their biology? Like, that's kind of a no-brainer. They probably already are thinking they could do that as a way to help them realign their thoughts and feelings. All right, I'm going to be going deeper with them. What have you experienced? What's at the root to your dissatisfaction with your sex? How did you learn to not like who you are? That's really where the conversation's going. Not, here, you should wear clothes that are more masculine and identify as a boy because that's what you are, and that'll change you. Like, give me a break.
But if the minor wants to start dressing like a boy to match his gender identity, not because he thinks it's going to change.
That's just not the way language works. Suppose that there's a rule that says you may not bring any dangerous animals in the park, including pit bulls. Doesn't that definitively provide you can't bring a pit bull into the park?
Yes, because a pit bull is a subsidiary of a dangerous animal.
My apologies to all the pity owners out there. I love pit bulls. The stigma against pit bulls really needs to cool off. But anyway.
But I don't think you can read an including to contradict the anchor term. So here, conversion therapy is an effort to change orientation or identity. If you read it to not mean that, then you've ruined that part of the statute.
All right,
I'm
sorry, go ahead.
I was just going to say, I can't say I like meat, including tomatoes and celery. That doesn't make any sense, and that's how we read this statute. And again, have been consistently read this statute that way from the beginning of this case in every pleading that we filed.
If you recall the example that I gave you, I'll give it to you again because I want to contrast it with another situation. So in the first situation, an adolescent male comes to a licensed therapist and says he's attracted to other males, but he feels uneasy and guilty about those feelings. He wants to end or lessen them, and he asks for the therapist's help in doing so. The other situation is a similar adolescent male comes to a licensed therapist, says he's attracted to other males, feels uneasy and guilty about those feelings, and he wants the therapist's help so he will feel comfortable as a gay young man. It seems to me your statute dictates opposite results in those two situations based on the viewpoint expressed. One viewpoint is the viewpoint that a minor should be able to obtain talk therapy to overcome same-sex attraction if that's what he or she wants, and the other is the viewpoint that the minor should not be able to obtain talk therapy to overcome same-sex attraction, even if that is what he or she wants. Looks like blatant viewpoint discrimination.
Bingo, exactly. Thank you, Alito. The state is telling the therapist and the client what their worldview should be, what their values should be. And that is a major overreach and clear violation of the First Amendment right there.
As I heard your examples, I think they would both be permissible because it didn't sound like in either case the goal was to actually change sexual orientation. And again, that's the touchstone because that's where the harms come from.
I don't believe you for 1 second. If he says, the client comes in and says, I want help with changing and reducing or eliminating my same-sex attractions, and she's going to say that doesn't count as changing so-called sexual orientation, then what on earth would count as changing so-called sexual orientation? It doesn't make any sense. You're setting up therapists to then be sued and have complaints against them by to their board. If you go and say, no, that's actually allowed, and therapists will be like, I guess I can do this then, and then all of a sudden everyone's going to attack them. It's a trap. That's what that sounds like. Sheesh. So inconsistent. Reword the bill then to be as narrow as it should be, to apply only to whatever it is you're talking about, but even what you're talking about is really making no sense. It's not clear what you mean then by changing sexual orientation. If you can change the attractions, if you can reduce or eliminate the attractions, that's okay. If you can change or eliminate the behavior, if you can change the identity, but you can't change the orientation, then what? That's totally contradictory. What do you mean then by orientation? Just another argument for why we should get rid of the whole concept, the social construct of a sexual orientation. See my video on dismantling the sexual orientation paradigm.
And if there is no goal being reached...
I guess I had the same kind of question that Justice Alito had. I mean, if we assume, for example, and this is a big assumption on your part, but just assume that we're in normal free speech land rather than in this kind of doctor land. And if a doctor says, I know you identify as gay, and I'm going to help you accept that. And another doctor says, I know you identify as gay, and I'm going to help you to change that. And one of those is permissible, and the other is not. That seems like viewpoint discrimination in the way we would normally understand viewpoint discrimination.
Thank you, Justice Kagan. Like I said earlier, I'm really pleasantly surprised by how reasonable she is in this this whole situation, and that she sees clearly this is definitely a viewpoint discrimination.
I don't disagree with that, Justice Kagan, and that's why medical treatment has to be treated differently. Because anytime you exclude one harmful practice, you are by definition saying these things are allowed because they are not harmful, and these things are excluded because they are harmful. That's the driving force behind regulating the particular practice.
And so Stevenson just blatantly doubles down on, yes, it's viewpoint discrimination, and we have the right to discriminate against this viewpoint, because this viewpoint is harmful according to all the LGBTQ activists out there. Not based on the evidence, but because it goes against their worldview and they want to impose that on everyone else. That's the reality. She don't want to admit that, but that is the truth.
Let me ask you about the standing argument. There's a statute on books, and if it prohibits what the petitioner wants to do, why doesn't she have standing? Why is it an answer, well, we haven't prosecuted her or anybody else under this statute?
I think it would if she said that she wanted to do something that violated the statute. And I think there's just been an ambiguity that has persisted in this case.
How on earth is there ambiguity? She's saying she is open to counseling clients who come to her voluntarily to work on changing, reducing their same-sex attractions, on resolving their gender identity from being trans toward being in alignment with biology. And based on the wording of the statute, that is clearly in violation of the statute if they're a minor. So there's no ambiguity. You're just problematizing everything now because you're realizing how unconstitutional it is. So you're backtracking on your definition.
What I can say is, if she does not want to engage in a therapy for the purpose of changing a minor's sexual orientation or gender identity, then she is not violating the statute.
Well, both the district court, which ruled for you, found standing, and the 10th Circuit, which ruled for you, found standing. And you didn't cross appeal on those, and not that you had to, it's standing. You didn't even put a Roman numeral in your brief on it, or even a subsection. It's footnote 18 on page 23. That doesn't exactly suggest that you have great confidence in that argument, does it?
Well, we recognize we lost it twice.
That was a great point by Gorsuch.
And again, it is the petitioner's burden, and it has been a persistent issue in the case, I think, in defining exactly what it is she wants to do. And to come back to this conduct
But
point.
if she does, consistent with a patient's, I'm reading the verified complaint, if I understand that to mean, paragraphs 86, 87, that she wishes to help clients who voluntarily come and with the desire to change their behaviors, expressions, attractions, and identity, then that would give her standing, wouldn't it?
Identity, yes.
Only identity.
The others not.
The others not, because of your peculiar reading of the statute.
So the main thing is identity. You can work on all the other things, but don't try to change identity. What is identity? These days, the word identity is used in such vague terms. That's why I reject the term identity, at least the common use of it these days. I argue that identity is actually something objective. And so we have a proliferation now of these so-called sexual identities and gender identities, but we need to get back to grounding in truth that there are only really two sexual identities, male and female. Everything else are just self-labels. They are ways of labeling yourself based on a sexual proclivity or romantic proclivity or lack of, a personality trait that may or may not be aligned with a certain sex. Like, all of these are self-labels. They're not true identities because they don't actually tell us anything about your intrinsic qualities. If you have the essential traits to be a certain type of a human, a male and female are quite easily discernible. You have to have the essential traits of the male reproductive system, or your organs being organized to be the one who donates the seed to bring about new life. And the woman has to be the one whose organs are organized to be the one that receives and nurtures that life, or the seed that then brings about new life. And right there you see that those two sexual identities are meant to unite. And so anything beyond that, or that differs from that, is not truly an identity, but some sort of nuance of someone's proclivities, their behaviors, their attractions. So your attractions may or may not be in line with the truth of your identity and the teleology of your bodies, of your identity. The man is meant for union with the woman, and woman for the man. So what we see with transgenderism and non-binary gender identities is a confusion of ontology, what you are, male or female. And with homosexuality and all the other sexual identities that follow with LGBTQ is a confusion of teleology, the purpose of male and female, to unite and bring about new life. So I reject using the current use of identity as something that's subjective, that's just a social construct, but rather I understand identity as something objective based on having the essential traits necessary for membership in a particular group. And we're talking about group membership based on sexual activities or lifestyles, then we have to recognize that those identities are transitory, or at least plastic, that they can change. And so why on earth would it bother us that people can change their sexual identity if we're talking about sexual identity being just rooted in your attractions or behaviors? We all know those things can potentially change. So it's weird to hunker down on identity changing when the things that they're using to determine identity, feelings and behaviors, are things that actually can change. So you allow us to change the feelings and behaviors potentially, but not the identity, when the identity is contingent on the feelings and behavior. Make sense of that.
But identity would. That would give her standing.
The change in sexual orientation or identity is the key to...
And that would give her standing.
That would.
Okay.
Because you're not disavowing that.
No.
Okay. So that settles the standing question.
Thank you, Counsel. Justice Thomas, anything further?
You rely on the history of regulating the medical profession quite a bit. What's the history of regulating therapists? When did that begin?
Right. So I would say mental health and healthcare delivered through words both were in full force at the founding of this country. At the time, that was done by people you might call physicians, and all of their practice was pretty much carried out through words and giving advice. As time went on and specialties developed further, and the mental health profession sort of came into existence, those same standards applied and governed psychologists and therapists. And then I would say the licensing of counselors as other professionals in the mental health field was sort of the second half of the 1900s.
With respect to this type of regulation that is a prior restraint on speech, what was the first example of that?
So, Justice Thomas, I want to push back on the notion that this is a prior restraint on speech.
It is a prior restriction on speech. You're preventing a therapist to speak with the client in such a way that is encouraging a type of worldview that you disagree with, that the state says that they should all have. So yes, this certainly is a prior restriction on speech. And I forget what she says next, but I'm pretty sure she has no example of the world of counseling and psychotherapy having a prior restriction of speech aside from these therapy bans. These are outliers in the world of counseling.
There's no enforcement of this law unless somebody files a complaint with petitioner's licensing board and she has an adjudicatory hearing and opportunity for judicial review and all those things. So it's like many other statutes in that way. It simply calls out a specific practice that violates the standard of care.
What's the specific practice? She'll say this a lot. A specific practice that violates the standard of care. But what is the practice? All right, you're using obfuscated terminology when you keep saying, "Oh, well, this is allowed, but this is not allowed." Just as long as you're not intending to change the orientation or gender identity. Well, what is the practice then? Now you're saying practice. Before you're talking about the goal. Okay, but what is the actual practice? What is the actual therapeutic approach that you're referring to? It's all confusing language from these LGBT activist types.
And those types of statutes have been around for a very long time. They were in the late 1800s. Those types of statutes governed medical professionals and then have been added over time as the mental health profession has developed and govern mental health professionals in every state.
Justice Alito?
Your argument depends very heavily on the standard of care, which I take it is defined by a medical consensus. Is that correct?
That's correct.
Have there been occasions, I mean, the medical consensus is usually very reasonable and it's very important, but have there been times when the medical consensus has been politicized, has been taken over by ideology?
Very good question there, Justice Alito.
We have no facts about that in this case, but I wouldn't disagree that that's possible. And I think it's a really...
Isn't it a fact that it's happened in the past?
I think
Three generations of idiots are enough?
I think that's certainly a concern. And if there were evidence of that in the record as to whether or not there were a standard of care that wasn't really based on patient safety, that would be highly relevant evidence.
What about the old ideology that all mental illnesses caused by brain defects and you can resolve those with lobotomies? And how about all the experimentation on African Americans and giving them syphilis and all sorts of diseases, using them for experimentation, like because, well, they're subhuman, so you can do whatever you want with them. You know, there's certainly an ideology that took over the medical consensus. How about just the recent scandal of this LGBT and it's just the trans issue? If we just looked at the trans issue, and see the scandal there. Like, you're not going to acknowledge that there's an ideological takeover? Give me a break. She's playing dumb.
Well, isn't that a reason to apply First Amendment scrutiny when what is being regulated is pure speech and not just saying medical standard of care or medical consensus? That's the end of the day. Rational basis review, anything goes.
No, Your Honor, because again, when we're talking about words used to deliver medical treatment, those issues are the same whether you're talking about words being used or whether you're talking about medical practices that don't involve words. Those issues are the exact same.
What medical treatment? If homosexuality is not in the DSM, it's not a disorder, well, how am I doing medical treatment? By just talking with them about it. You can't have your cake and eat it too. You can't, on one hand, remove homosexuality from the DSM, and then on the other hand tell us how we should address it with clients when they want to talk about it with us. Knowing that people can seek out therapy for any issue. It doesn't have to be just for something that's in the DSM. Only has to be something in the DSM if they're seeking insurance reimbursement. So now maybe the trans issue, because there is gender dysphoria, which really they should get rid of the diagnosis of gender dysphoria and put back gender identity disorder. But with that, I can understand maybe that argument she's making because there's still a diagnosis there. But when it comes to the SSA, they're trying to have their cake and eat it too.
And there is nothing about this statute, for example, that stops anyone from sharing any opinion about conversion therapy or about how the consensus on that was reached. And again, in this case, there is just no evidence of any motive by either the Colorado legislature or any medical association to reach this conclusion on anything based on anything other than protection of minors and a decades-long record of research.
Was there a time when many medical professionals thought that certain people should not be permitted to procreate because they had low IQs?
I don't know that, but I will accept the premise.
Accept the premise. You know the truth. Give me a break. Alito's getting on to something here, and she's going to play dumb each question he has.
Was there a time when there were many medical professionals who thought that every child born with Down syndrome should be immediately put in an institution?
I don't know that, Your Honor.
Thank you.
Justice Sotomayor? Justice Kagan?
I could go back to your example about having high cholesterol and all the various things that a doctor could say. And I don't think like anybody wants to remove doctors from liability or any kind of professional sanction for giving utterly wrong medical advice just because the giving of that advice involves words, right? So if the doctor said you can lower your cholesterol by going out and eating dessert every meal, we would think that was like not a good thing for a doctor to say, and we wouldn't say, oh, the First Amendment has something to do with this. But I guess I have this feeling that that's a different kind of case, that is a case where the speech is incidental to whatever conduct it is that the doctor is offering. Whether it's, you should take this pill, or you should do these eating practices, or so forth and so on. And are you saying that there's no distinction between what we're dealing with here and the range of things that a doctor can tell you in her office about what kind of care is appropriate for any particular condition?
I don't think there's any distinction, because just like in the medical field, counseling is an evidence-based practice that petitioner trained for thousands of hours to be qualified to do. And her advice and counseling therapies, through her words, can be extremely harmful. And so there is no difference between that and the medical context. And I wanted to come back to the first part of your question about calling out a specific practice that violates the standard of care. This is a thing that legislatures do, not irregularly, when you have a practice that, although it's ineffective or although it's harmful, it persists anyway. So for example, in Colorado, there's a specific provision that says it's unprofessional conduct for medical doctors to prescribe anabolic steroids for sports performance. Now, normally something like that might die out, but you can understand why there are cultural pressures that make this continue to be interesting to people, even when they know there's harm. And this has been the problem with conversion therapy. Although every theory that it's relied on has been debunked and debunked and debunked.
This is going to tick me off right here. Debunked, debunked, debunked. No, censoring alternative theories aside from the born that way theory is not debunking the other theories. There actually is evidence showing the triadic family, the family of origin issues being a contributing factor for a subtype of same-sex attraction or homosexuality, of trauma being a factor, of just there's evidence for multiple theories, but what the APA denies is there's not consensus on one single explanation for what causes same-sex attraction or sexual orientation of any sort. And we would all agree, yeah, there's not one single explanation, because there's a variety of ways in which one may develop their particular sexual attractions and sexual arousal templates. That doesn't change that the different theories proposed, the validity of them. So debunking, yeah, she uses that term way too loosely.
People continue to seek it and to want it and to believe that they can make this change. And I think that's understandable. It's a challenge to find out that you're a gay or transgender person. And then finally, to the issue of regulating a specific practice, we cited you a couple of cases about this false memory recovery. So there was a practice going on with psychotherapists in the 1990s where they were using a therapy that was causing children to come up with false memories of sexual abuse. And there were several malpractice cases about it. That therapy died out on its own.
It's interesting she brings up this point about the phenomenon of false memories and that whole scandal, which if you really should study, because it's not as cut and dry as people would like to talk about it in hindsight. There were actual cases of people coming to a therapist to work on trauma after they already had memories that were repressed come up. It was oftentimes before they even started therapy. But some people obviously ran with it, and you had copycats, and some therapists might have been coercive or influential in trying to suggest clients experience some sort of trauma or abuse when they didn't. Yes, that's a phenomenon. But she just admitted that it died out. Okay. So, because it showed that this whole thing was definitely harmful and it was not effective. But why has the effort to obtain therapy to explore changes in sexuality and gender identity not died out? Because people are finding help, and they want to have access to effective forms of therapy for this issue. But also, you've been banning it instead of just letting it die out naturally, despite evidence that the population you're banning it for has actually even experienced it or been actually harmed or by it in some way. Minors. So you are preemptively banning something instead of just letting it die out if it really isn't effective. Like, let it play out. If you're going to use the comparison to the false memory phenomenon.
But if it hadn't, and therapists had continued to do it, and again, it was practices at all. And then I would direct you specifically to the Green study and the Turbin study. The Green study looked at 34,000 13 to 25-year-olds who had gone through conversion therapy, and after controlling for other factors, found there was a 2 times rate of attempted suicides among that group. And in the Turbin study, Dr. Turbin looked at 27,000 participants. This was specifically on gender identity change efforts, including people who had received those efforts under the age of 10. He looked specifically at childhood exposure and found association with adverse mental health outcomes in adulthood, including suicide ideation and attempts. This question about whether it's voluntary or not, that's just not an issue that had ever been raised to focus on. And especially with children under 10, I don't even know how you would assess that. I would also direct you to Dr. Turbin's amicus brief, though, where he further describes the techniques that he used in his study to show how much they would align with, I think, what petitioner would imagine that she would want to try to do.
What these studies don't show is causation, that them doing this therapy is what caused their suicidal ideation or emotional distress. But rather, these are likely, like I was saying before, usually it's the individuals who are the most distressed, either because of their sexuality or gender confusion, or because of other issues in their life. They're more likely to have been survivors of trauma, or dealing with addiction issues, or have relational problems. And so those are likely the roots to the distress, and the therapy may or may not be helpful in resolving those issues, as well as what they would consider the presenting problem, their sexual orientation or gender identity. So to say that the therapy is what caused it is likely not controlling for all the factors that she says it's so-called controlling for. Not to mention a lot of the studies that apparently are purported to prove all the harm of so-called conversion therapy do not factor in the time at which they experienced suicidal ideation. If it was prior to experiencing what are they called, SOCI or conversion therapy, or if it was subsequent to it. So upon reanalysis of, say, the Blaznic study that used the Williams Institute's generations data, that is supposed to be a representative, I have doubts about that. But even with that, showing all this suicidality among people who had a lifetime experience of so-called conversion therapy, reanalyzing the data, Paul Sullins showed that the suicidal ideation or attempts preceded the intervention, whatever it might have been, rather than was a result of it. Even if there was subsequent suicidal attempts or ideation, it preceded as well. So the therapy may have helped reduce it, may not have reduced it, in cases where it continued afterwards or reoccurred, or there were cases where it eliminated suicidal ideation and attempts. So when you actually factor in the timing, when did the intervention occur in relationship to the suicidality, we get a very different picture from what activists like all the Trevor Project and the Williams Institute and basically all the mainstream organizations try to promote.
And then you have to put it in the context of people have been trying to do conversion therapy for 100 years with no record of success.
This is the most ludicrous thing she says. No record of success. Let me give a sampling of the records of success that the establishment does not want to acknowledge. Nicolosi, Bird, and Potts in 2000 did a retrospective survey of 882 participants in safety or sexual attraction, fluidity exploration, and therapy. Also maybe just called reparative therapy or SOCI at the time. After treatment, over 34% reported a shift from exclusively homosexual to exclusively or mostly heterosexual. 67% reported exclusive homosexuality prior to therapy. So the vast majority of them reported having only same-sex attraction, whereas after treatment, 12.8% reported exclusive homosexuality. So a major reduction in the intensity or the exclusivity of their same-sex attraction. Bird and Nicolosi, 2002, a meta-analysis of 46 studies, most of them from before 1975. So she talked about, we've been trying to treat this for 100 years. Well, here's a good analysis of all the studies from the earliest years of treating same-sex attraction. And they found that in this meta-analysis that therapy for homosexuality was 79% more effective than therapy for other issues or control groups. Now, of those 46 studies, most of them were likely psychoanalysis rather than the behaviorist techniques that were being studied in the APA 2009 Task Force report. Though I think their meta-analysis was pretty inclusive, included both behaviorist techniques as well as psychoanalytic ones. Schindler and Schroeder, 2002, the one study that actually sought to document the harm and failure of sexual orientation change efforts, inadvertently reported some efficacy. They had 202 respondents in their study. 26 of them reported therapy success, experiencing shifts in all dimensions of orientation, thoughts, feelings, behaviors, identity, toward heterosexuality. So the very study that was designed to prove the harm of so-called homophobic therapies ended up inadvertently undermining their objective and proving that it can be successful for some people. Of 202 respondents, 26. That's not negligible. Spitzer, 2003. This is a big deal and a controversial study. Robert Spitzer was the key psychiatrist in removing homosexuality from the DSM. But he also was very open-minded. And after years of hearing people say, hey, I've experienced change in my sexual attractions. I'm no longer gay. I'm ex-LGBT. Or I've gone through therapy or ministry approaches, and I've experienced change. He heard those stories, and so he wanted to investigate claims of change in sexual attraction. So he did retrospective interviews of 143 men and 57 women who did some form of SOCI, whether it was therapy or ministry approach. And his study, based on their, obviously most of these studies, aside from the Peel and Sutton study that we'll get into in a bit, were retrospective, and client self-report. But that's a decent sample size he had there. And what he found is that by the end of their treatment, 17% of the men and 54% of the women reported exclusive opposite-sex attraction. And he was vilified for doing this study. He was seen as a traitor for doing such a study. He was pressured into denouncing it 10 years later when he was essentially on his deathbed. The LGBT activists came after him so harshly. Carton and Wade, 2010, interviewed 117 men who did safety. Prior to therapy, the average had predominant homosexual attractions. After therapy, the average had predominantly heterosexual or equally both homosexual and heterosexual attractions. And notice how non-sensational their outcomes are. They're not claiming like complete radical change. If you look at all these different studies, they're showing changes on a continuum, shifts to different degrees for various people. So none of these studies are claiming something that's totally outrageous and unbelievable. But there is evidence of change that is simply not being acknowledged. And the biggest one, because all the other previous studies are mostly retrospective, self-report. Schindler and Schroeder, the average age or the average length of time for the recollection was 12 years. So their average participant in that study was 12 years removed from the therapy intervention that they're talking about, or whatever the intervention was. They didn't make a distinction between ministry approaches or pastoral care and actual licensed professional therapy. So you're asking people to recall what their experiences were for something prior to 12 years ago and then afterwards. You're not going to get the most reliable data. What we need are prospective experimental studies. And so we got that with the Peel and Sutton study that was published in 2021. 75 adult men who were doing reintegrative therapy to do a trauma treatment to explore seeing if it led to changes in the different dimensions of sexuality and also if it improved well-being. And what they found was the same-sex attraction decreased significantly and the opposite-sex attractions increased significantly. and the sexual attraction identity shifted toward heterosexual, and the same-sex attraction experiences decreased in frequency and degree of sexual explicitness. So this is regarding the effectiveness, but also when it came to whether or not it was harmful, they used the OQ45 and found that they vastly improved in their well-being. Prior to treatment, they were experiencing significant clinical distress. After treatment, actually while they're doing treatment, because they assessed every 6 months for up to 2 years, by the time of their first post-test, the first 6-month reassessment, well-being dramatically improved. So there's data that no one is talking about.
There is no study, despite the fact that people tried to advance this practice, that has ever shown that it has any chance of being efficacious. And again, the harm from it comes not from the aversive practice, it comes from telling someone there's something innate about yourself you can change, and then you spend all kinds of time and effort trying to do that, and you fail.
But you bore the burden. She didn't have to show that it was efficacious, right? You had to show that it caused harm.
Right, but in light of 100 years of studies that all point in the same direction with no efficaciousness and evidence of significant risk of harm, we think we amply carried that burden.
Tell me more. You said that in the 10th Circuit, you wished, because if you had been back before the district court, you could have introduced more evidence. Did you not? It was a PI hearing. Why didn't you have the opportunity to introduce all the evidence you wanted to?
There was no hearing. We filed a response in response to petitioner's brief where she had no evidence. We put in a 60-page expert declaration covering all of this, and including not just the studies, but the fact that all of the theories underlying conversion therapy have been debunked. Initially it was homosexuality as a pathology that we need to treat. That's been debunked. Not debunked, just fell out of favor. Okay? It all depends on how you define pathology. When the definition used for a mental disorder has become increasingly more subjective and based in more consequentialism rather than a grounded definition of human anthropology, then it falls out of favor easily. So as long as it doesn't cause distress for people, then it's no longer a disorder. And if it's not statistically significant, then if it's more common. That's why there's always this push to say that 10% of the population is gay. A misreading of Kinsey's data. It was to show that, it must not be a disorder if 10% of the population is gay, because if it's that frequent, surely it can't be a disorder itself. So something falling out of favor does not mean it's been debunked. It just means that it's being rejected on ideological terms. Then it was homosexuality is caused by trauma. That's been debunked. That's been debunked? Trauma? We know that individuals with same-sex attraction have a higher occurrence of childhood trauma, have higher ACE scores, adverse childhood experiences scores. And the treatment that we do is primarily trauma treatment, and we see that that has an impact on the sexual attraction experiences, not to mention the gender identity experiences. So it's reasonable to then conclude that the trauma must be at the root to the sexual identity issues and the gender identity issues. So no, not debunked, just against your narrative, and you don't like it. Then it was homosexuality is caused by a relationship you have with your parents. That's been debunked. Not debunked at all. It's well known that men with same-sex attraction, in particular for male same-sex attraction, had, on average, overwhelmingly, conflicted relationships with their fathers. Enmeshment with the mom is a frequent experience. Not debunked, hard to prove definitively, and also you can't necessarily use a blanket explanation for all cases of same-sex attraction. So that's the fatal flaw of all these theories, is that there's not one theory that explains all forms of homosexuality. But there doesn't need to be one theory to explain it all for these different theories to have validity, because there's a variety of ways in which people can arrive at experiencing same-sex attraction or gender identity confusion. There's not even a
just on the
working
very
theory
specific
now.
evidentiary question, are you representing then that if this went back, you want the opportunity to have a hearing to put in different evidence that it causes harm?
I think if there's some, argument that we need to show that these studies were done on people who engaged in voluntary therapy, I think you could potentially go to the study authors and get that. But that particular critique was never raised. And again, I just think if what petitioner is saying is you have to have a randomized controlled trial on children in order to establish with respect to the particular thing that she wants to do, that would be, I think, a study that would, not even medicine would require a study like that to come up with a standard of care.
Rebuttal, Mr. Campbell?
All right, James Campbell, Alliance Defending Freedom attorney, is going to have the last word here, and I love what he says.
Thank you, Mr. Chief Justice. On standing, Justice Gorsuch, in response to your question, I heard the state say that they are not disavowing enforcement, particularly if the effort involves discussions that seek change on identity. On pages 216 to 217, Ms. Chiles talks about how she wants to have full conversations exploring issues of identity and gender, and that includes considering change. On the issue of studies, there was a reference to the Green and Turban studies. All of those studies relied on bias sampling, self-reporting. They conflated aversive techniques with voluntary counseling. They did not isolate licensed counselors, and they did not purport, even in their own study, to prove causation.
Boom, exactly what I was saying earlier. Knockout blow right there.
Beyond that, Justice Thomas, in response to one of your questions, the state conceded that it would be speech if it was a life coach, but it's for some reason not protected speech if it is a professional. That is an attempt to revive the professional speech doctrine that this court rejected in NIFLA. This law's viewpoint discrimination is even worse than we've heard so far this morning, because the state of Colorado would allow a 12-year-old without their parents' consent to enter into counseling that would go the opposite way on these issues of gender identity and sexual orientation. But if that same 12-year-old with their parents' consent want to seek counseling in the opposite direction, the kind that my client would provide, they are not able to do that. That kind of viewpoint discrimination must survive strict scrutiny.
Powerful statement at the end there.
This law harms gender dysphoric kids because the statistics that we've cited in our verified complaint, as well as in the brief that we cited with this court, indicate that 90% of young people who are struggling with gender dysphoria before puberty work their way through it and realign their identity with their sex. But if one of those children go to a counselor and they specifically say, that is the help I want, realigning my identity with their sex, they cannot receive that help from someone like my client. Moreover, if they're continuing down the path of transition, then unfortunately, they get locked into that path, and eventually it leads over 90% of the time, once they start down the path of social transition, it will lead to the route of medicalized transition, which the Cass report tells us comes with a lot of harm and devastation. And lastly, there should be no remand in this case for all of the reasons that I just explained. In addition to that, I heard Ms. Stevenson say that they were aware below that we were arguing for strict scrutiny and that they had an opportunity to put studies in. So all remand would do in this case is continue to prolong the ongoing harm that's happening not only to my client, but more importantly, the kids who are struggling with gender dysphoria.
Thank you, counsel. The case is submitted.
All right, boom, right there. There you have it. So those are the arguments. Getting a little lost in the weeds with some technicalities in the middle, so pardon me if I skip some things there. But it looks very good for our side. It's like, this is what we've been waiting for. Just give us the opportunity to state our case and clear out the myths about what we do, and also to just point out just the injustice of these bans and how they're taking advantage of the vulnerable by giving them only one option, LGBTQ affirmative therapy, and that they're actually predetermining the outcome for our clients instead of letting them choose their own goals. So ADF, Alliance Defending Freedom, did an excellent job. The solicitor from the Department of Justice did a great job. I don't know if the justices were ready for just how ready we were. We've been chomping at the bit to do this work. So they have amicus briefs from my colleagues, from those of us who've been fighting this fight for years. Kaley, you're going there not just representing yourself. You're representing all of us who've been demonized for doing this type of work. Like myself, who was kicked out of graduate school 4 weeks away from graduating because I dared to help other men with unwanted same-sex attraction in just coping. I wasn't even trained in how to actually target the attractions, but just helping them with coping. This is why you see there's a chilling effect, because once any aspect of so-called conversion therapy is codified and demonized, outlawed, then loose interpretations can be applied and used to persecute dissenting graduate students and therapists, but more above all that, to persecute clients from obtaining the therapy that they want, that aligns with their values. And that's what we have to fight against. So if the court does not rule in Kaley Chiles' favor, it would be a travesty, especially when you see the strong case that her team made and the questions from the justices showing that they really do understand where we're coming from and they see the validity in our arguments. For them to rule the other way, it would make no sense. It would be a huge miscarriage of justice. So we're expecting a decision, from what I hear, by June at the latest, hopefully earlier. That's why I've been making so many of my videos, gosh, for the past few years, but especially lately, about this issue, about the legality, about the ethics of therapeutic choice for individuals who want to explore the potential for change in same-sex attraction and gender identity. Building the case. If you're curious, you want to learn more, check the links in the description. I always provide, if you want to go down the rabbit hole, I provide all the links to previous videos that will go more in depth with what I'm talking about here. Please, if you're on my side with this, please pray. And lift everyone involved in prayer. Pray for our nation. Pray for each state where there's these bans or they're proposing bans, that true justice will prevail. And please drop a comment, like, subscribe, share this with others. Be bold. Share the truth with other people. Until next time, please know, Jesus loves you freely, fully, faithfully, and fruitfully. Take care.